of Law, I would like to thank FIDA for the partnership that they share with the School of Law for a very long time. Can we please clap for FIDA? Thank you very much, FIDA. This is I think there's even a FIDA club, students club in the university that is very vibrant, and they are very happy, and the gentlemen usually meet me and say, we want to be members of the FIDA club. We have to be included. FIDA should not exclude us. So we have males here who are very diligent and interested, and I think the good thing with the FIDA club, it has opened up to the male also within the university fraternity. So that is also very impressive. But the learners are very active. They enjoy FIDA. They told me, you see, FIDA has made the room today, the university, very beautiful today, the faculty. And just talk to the FIDA ED so that they can leave the stage here for the entire weekend. So that is a request I'm putting forward. Please consider. Somebody even told me, there's even SC at the faculty these days. Yes, there is SC courtesy of FIDA. So but by Monday, then we shall go back to our natural SC. Yes. So we thank FIDA really for all the activities and the beauty that they brought to the School of Law this morning. Also, FIDA's partner, IDLO, that has been also privy to supporting the activity. We are very grateful. The director or the country director for IDLO will speak later, so I'll not delve into that. And ladies and gentlemen, the students who are here, let me also recognize and appreciate the participation of our partner universities that have come. Maybe they could just stand up for recognition, the deans, lecturers, and coaches that have come from the partner universities, so that our learners get to see you and know you. Thank you. I think we shall have them introduce themselves. Yes, thank you for clapping. Yeah, please don't step their toes and think that they are one of you. Some of you might just start stepping toes and pushing around. You know, they all look young and very beautiful like the rest of you. So you need to take note of them. I'm going to let them introduce themselves and the universities that they are from in just a bit. So the context of this Moot, I think the FIDA ED will also, CEO will elucidate further, but it's really touching on the perpetual problem of women's rights and access to land. The resource, a very vital resource, land, especially in our customary settings. We have students here from up to 4th year who have studied land law already. They've studied family law, at least those from 2nd year and above. And they know we discuss some of these dynamics in the classroom. Patriarchy, cultural norms and practices that continue to hinder access to resources, vital resources like land. Because when you look at our constitutions, you look at the Land Act and so on, they are gender inclusive, and everybody has got a right to actually own land in there. However, the reality on the ground remains different and very challenging. The concept note has got the statistics of the level or the rate of ownership of land for women, especially in the customary setting. And the moot question that we are dealing with today is also painted within that context. And we want to appreciate the arguments that the councils will come up with respect to land rights of women, and also the perspective of the bench, our judicial officers, as they assess the performance and give their ruling. For us as a School of Law, we do not underlook such an activity. The School of Law and the broader Makerere University. Our strategic plan speaks, among other things, to transforming learning. Learning, ensure that our learning is transformative, and our learning also changes society, addresses challenges as well in society. And using a moot event is one of our pedagogy methods in enhancing learning. Moots are critical and important, vital aspect of our training of our learners. We have very many, we have a mooting club within the faculty, and in the year they participate in almost 13 moots, if I've got it right. Edison, Langa, about 13 of them. There is space moot, even things where I don't know anything. If they ask me anything about space law, I have no clue. But you hear the students saying, we are going to the Geneva to talk about space law. We are going, I don't know where, talk about the African human rights moots and so many other moots. So we take mooting very seriously because it develops the learners' research skills, critical thinking skills, presentation and oral presentation skills. Even since it's a mock trial, we are also developing their advocacy skills. And this is what we have to do as trainers of our young lawyers in the legal fraternity, so that by the time they leave the law school, they do not fear a bench. We've heard of people collapsing in the courtroom, even they are just witnesses, but they are collapsing. The days I practiced actively, I had a colleague, whenever I would be going to court with her to apply for bail or do what we have to do, she's shaking. And I remember several times I would tell her, you're not the accused. You just relax. You've gone for a bail application, but counsel is shaking. Why is counsel shaking? Because counsel has not been exposed to that audience where you're going to be before a judge with a wig or a magistrate and you have to make a case for a client, and counsel now is just so traumatized by the whole event. But when we start tooling them from here, then they get, it's familiarizing them with everything. By the time they get to actual practice, the only difference is now they are real clients. And they know that they have somebody's life in their hands. They are no longer hypothetical questions that they are dealing with, but at least the dynamics, the skills, the etiquette, the professional speaking, appearance, and so on, they will have acquired it from the law school. This kind of initiative has actually improved even our collaboration with the Law Development Center, because we have a clinical program where we have many activities, including Moots, provision of legal aid services, and the students participate. They are part of it's a student-centered project. So they participate in all of these activities. And that is the Law Development Center also has a clinical program now. And usually they write to us and say, can you give us the names of yours, that they build the capacity of other students across the clinics of Law Development Center. So our clinical program and the mooting exercise with all the other activities we do has also reinforced and deepened our engagement and partnership with Law Development Center. So we want to really thank FIDA and all the other partners that endeavor to reach Makerere School of Law, to partner with them for such exercises. As you have seen, this is the second Moot. The pictures have been up there showing the first Moot, which was last year and was hosted by Cavendish. So the rules of the game is the Moots will be, the hosting will take rounds. So my learners from Makerere University, you have a duty in your hands today to be very good hosts. Okay, when we were in Cavendish last year, we were warmly received. And even when we won, you say winning on home ground. Now today we are on home ground. You know me, I'm not a footballer. I don't know those things. When we won in Cavendish, it was still, there was no aggression, there was no nothing. They enjoyed the win with us. So whatever happens today, I expect that Makerere University will warmly receive also the outcome and, enjoy whatever outcome it is with the winning team. Remember, we are all hosts. It's not just me alone and the principal and so on. Even you, the learners from Makerere University, in your different capacities. So, with those few remarks, allow me to give the MC the room to invite, I think, the ED from FIDA to also say more, and also about the program, and then the afternoon bit of the program. Thank you very much.
Thank you very much, Madama Team. Madama Team is also a member of FIDA. Maybe just to say a few things about FIDA. For many of us that may not be familiar with it, we enjoy a dual identity as a feminist NGO that prioritizes rights of women and children, but also an NGO, an association that brings together women lawyers for capacity building, but also to enable women lawyers participate in this competitive sector properly. I'd like to just mention and also appreciate again Cavendish University for hosting us for the last, which was our first. I'd also like to appreciate the teams that participated in the last Moot that we had at Cavendish. For those that were not around, we had this particular one in collaboration with the International Association of Women Judges and FIDA. And this collaboration, like Madam Atim has said, was one that was used to explore also another subject that we find very important in FIDA, that is in adjudication of sexual gender-based violence cases. How do we have a gender approach, gender perspectives in adjudication of those cases? So I just wanted to FIDA Uganda to also give her remarks, and then we'll get into the program of the day.
Good morning. It's heartwarming to come into a room full for an event like this one. So to the mobilizers, Dr. Patricia, thank you for making this happen. I've already been introduced. My name is Lilian Yarugaba Adripo, and I'm the team lead at FIDA Uganda. So speaking on behalf of the board and the secretariat. So representatives from the judiciary, your worships in the room, the private practitioners, from your different platforms that you practice your trade in, delegates from the development partners that some of them are online, they are listening in and they will join us later in the afternoon, civil society present in the room, students from your respective universities, our hosts, faculty members of Makerere School of Law and the public PILAC, Public Interest Law Clinic. A very good warming to you all, and we welcome you to the second National Inter-University Gender and Human Rights Law Moot Court Competition, FIDA at 50 edition 2024. This year's Moot Court competition is particularly significant, not only because it focuses on pertinent issues, which we are grappling with in the legal profession, but also comes at a time when FIDA Uganda marks 50 years of existence and is working towards further advancement of rights of women and children. We are looking at what we can do differently in the next decade. As an organization, FIDA Uganda has stood the test of time since its inception in 1974. Our journey has been one of learning, perseverance, success, and growth from strength to strength. We've also registered some failures. We are not embarrassed to say that. While we have inevitably experienced challenges and setbacks, we have celebrated the progress made towards our mission to advance the rights of women and girls and to achieve gender equality in Uganda. We are immensely proud. Sorry, my cursor is not doing a very good job. We are immensely proud to be contributing towards the national, regional and development agendas, including SDG 1, 2, 5, 8, 10, 13, and 16. That is a whole lot of work that we are doing to contribute to the development agendas. And these SDGs speak to ending poverty, ending hunger, gender equality, promoting equality, decent work and economic growth, reduced inequalities, decent work and economic growth, reduced inequalities, climate action and peace, justice and strong institutions. We have done a lot of work through our Access to Justice strategic objective, and through this we have legal aid clinics across the country, and through these clinics in the last year alone we reached out to 25,000 women in nearly all the regions in the country to obtain redress for various forms of gender-related rights infringement and violations, ranging from deprivation of poverty to gender-based violence. Our legal services are commonly community-centered and are offered through various collaborative approaches that are tailored to the needs of communities that we serve. We have, through this service, secured land valued in the billions on behalf of our clients. Our efforts is, however, still a drop in the ocean. Legal and policy reforms we have, through our 50-year journey, our commitment to breaking down structural barriers to access to justice for women and girls, as well as the enjoyment of their rights, has been unwavering, using various advocacy interventions, including dialogue, lobbying, and strategic litigation. We have made efforts to secure legal, policy, and normative reforms. From as far back as the 1980s, we have been at the forefront of advocating for family law reforms in Uganda through analysis of, as well as a discussion and debate on the gender equality and equity compliance of bills that impact on women's dignity and socioeconomic rights within the family unit. Among these are the Domestic Violence Bill 2009, which was eventually enacted into law as the Domestic Violence Act in 2010. The Domestic Relations Bill 1980, the Marriage and Divorce Bill 2009, which the Uganda Law Reform Commission developed basing on, among other considerations, a report on the Domestic Relations Bill 1980, the Marriage and Divorce Bill 2017, and most recently, the Marriage Bill 2022. We also secured gender progressive reforms in the Divorce Act, which through the use of gender-focused strategic litigation in the landmark case of Uganda Association of Women Lawyers and 5 others against the Attorney General, Constitutional Petition number 2 of 2003. Through that petition, we nullified provisions that restricted legal redress for women under the Act. At FIDA, we apply the gender transformative approach to litigation. And in addition to being an advocacy institution, FIDA Uganda is also a membership and professional development organization, as Elizabeth has already told us. And as such, we are committed to the professional growth of our members and lawyers in the making, building knowledge, skill, and capacity to effectively use the law as a tool for gender justice. It is with this objective that we formed the FIDA Uganda Leadership Academy, a rapidly growing arm of our operations, through which we have tailor-made programs and activities that enhance the capacity of lawyers to advocate for the rights of women and girls in Uganda. Among such capacity enhancement tools is the annual National Inter-University Gender and Human Rights Law Moot Court competition, which we inaugurated last year. This competition is key to enabling young legal minds appreciate gender proactive and transformative litigation and adjudication of cases, which is quintessential for the development of gender progressive jurisprudence in Uganda. The theme for this year's Moot competition is family law reform now, bridging the gender gap in access to land as a productive resource. And this is highly relevant to the times that we are operating in, especially in view of the developments on matrimonial property rights, both in the courtroom and in the legislative house, that is Parliament. We recognize the persistent barriers as an institution, that is the limited access to land ownership, use and control by women. We also recognize the gender disparities in access to land, access and use of land, and the disproportionate effect of evictions and displacements on women and children, and thus the need for such platforms. As we argue the case before us today, as we litigate and as we adjudicate and actively listen in, let us remind ourselves that 70% of women rely on agriculture, only 20% of women, the world's population, own their own land, 40% lack secure land tenure, and only 20 to 30% of women, 20 to 30%, they earn less than 20 to 30% less than their counterparts, that is the men. So even after 50 years of programming, the odds are still against us as women. It is therefore with the utmost gratitude that I thank our development partners, IDLO and the Swedish Embassy, SIHA, and the Generation G programs with the support from the Dutch Ministry of Foreign Affairs for supporting this discourse this morning. I'd like to thank the International Women Judges Association through their chair, Justice Alvisa, for making time amidst their very busy schedules to preside over this moot this morning and in the afternoon. I'm certain that you will have a lasting imprint on your minds. as the students appear before you. We also want to thank the judges for the day, for making time to appear before us. And I would like, in a special way, to thank the team at the Makerere University Public Interest Law Clinic for making the room beautiful, for mobilizing, as I already mentioned. And would also like to appreciate Makerere Law University School of Law for being such gracious hosts this morning. I hope that you will make sense of what we are talking about today, and that you continue to use this information as a tool for advocating for gender parity as we go about our business. Before I hand over, I'd like to thank Susan Baluka. She's been the coordinator for this event. She espouses a spirit of excellence, a great value that we have as an institution. Susan, thank you for bringing us together. I wish us all very good deliberations this morning. Thank you.
Thank you very much, FIDA team lead, Lillian, for your opening remarks. I think she speaks more about some of our achievements as we reach 50 years. And I just thought at this particular juncture, I would also like to recognize the leaders of the different student chapters that we launched last year. I know that we did have one in Makerere University, another in Mukono, in Kampala campus and the Mukono campus, and we also have one in Cavendish universities. We are excited to do the work that you're doing. We are seeing you. I'd like to particularly recognize the team from Makerere FIDA University chapter who've been pushing a campaign against sexual harassment of girls and women at the universities. We see you and we support you. Please feel free to always reach out to our coordinator, always reach out to any of the FIDA staff for any kind of support for such campaigns, because when we work on such things, then that's the only way we are able to achieve the gender equality that we are seeking for. So thank you very much. For the next part of the program, I'd like to invite a friend of FIDA. I know that many times, even when we're launching the campaign, the male said, you know, we get involved. And I think we did share on how you get involved. And Nicholas Odot, the next person who will be speaking and leading us into the next session, is one of those examples of how we engage men, of how we engage boys in the kind of work that we do. So we do not segregate against men or boys. We do have a male engagement strategy that mirrors the national engagement strategy, male engagement strategy under the Ministry of Gender. And it's through that strategies that we do ensure that we're engaging the men and boys as allies, but also on addressing issues of them being perpetrators of the different forms of violence. You're welcome, Mr. Nicholas Odot.
Good morning, ladies and gentlemen. Good morning. Happy anniversary, FIDA. It comes with cheers, so happy anniversary, FIDA. Thank you. So for the next part, we are going to begin our all-arounds for the matter of Rita Izoma versus Robert Okoye. We have 2 courtrooms. Each court session will be 1 hour, 30 minutes aside. This will be our courtroom 1. That will be Team C versus Team D. Team C are the appellants. Team D are the respondents. And then courtroom 2, which is on the first floor of the White House. Yes, lecture room 1. It will be Team A versus Team G. Team A versus Team G. We'll take a 30 minutes break. Then we'll come back to the same court sessions for round 2. And that will be Team G versus Team C here. Then Team D versus Team A in the White House. So for the first round, again, we shall have Team C versus Team D here. And then Team A versus Team G in the White House. That will be it. Thank you. The Moot can get going. Thank you.
As we make our way, kindly allow me a minute to recognize the representatives from other universities. And I'd like them to just take a minute to introduce themselves, and then we can move into our respective courtrooms. Like I mentioned, this is a collaboration between FIDA and these 4 universities that have generously accepted to do this with us. So let's kindly give them a minute to introduce themselves, and then we can continue to the different courtrooms.
Thank you very much. Good morning, everyone. I am Dr. Olawunmi Opeyemi Obishesan. I'm the head of Department Clinical Legal Education, Kampala International University, and we are happy to be here. Thank you.
You're welcome. Thank you very much, and it's nice to have you.
Good morning, everyone. My name is Fancy Jendalake. I'm a lecturer at Gulu University and the head of Department for Private and Commercial Law. Thank you.
Thank you. A big shout out to Gulu University. We did not have a university from upcountry in the first one. We took the feedback, and we now have Gulu as part of the Moot competition today. You're welcome, Gulu, and thank you so much for the collaboration.
Okay. My homies.
Yes.
Okay, we'll introduce others later.
All right. Okay, I think let's get into our courtrooms as directed. The other courtroom is at the White House. The session will be strictly timed, which is an hour. I think timekeeping is part of the practice of the law. So let's kindly move to the rooms. Nicholas is going to be part of the 2 rooms. He will be giving any guidance. But in case you see anyone with this shirt, please also feel free to ask for any kind of assistance from the FIDA room. IT, you can take over in the meantime. Nicholas, kindly come to the lower auditorium. We need assistance from you.
Okay, there were 4 teams that made it to the oral rounds. Of the 4 teams, we had a duffel draw today morning where teams picked their opponents. Everyone picked a paper, and that's how we came about which team is versing which team. The teams are aware of that. And then, for those who intend to follow the Moot problem question has been shared at the registry table. You can pick a copy and be following the proceedings of court. Thank you.
We don't all have to stay here. There are other 2 teams that have gone to the White House. So if we could split each other to have some members go to the other court, then that would be great, because I see that many of us have stayed here. For the FIDA team, FIDACOM's team, kindly also devise means of having some members stay in the room, and then the others to also go to the other courtroom so that we are able to capture proceedings from both courtrooms. IT, in the meantime, please take over with the videos. as we prepare for this particular session. The 2 sessions are going to take an hour each and are going to be strictly timed because it's part of the legal profession, really, to keep time, right? So let's kindly have some more people go to the White House and then we shall be good to go. If you do not have a copy of the problem at the registration desk, we do have some copies. If you prefer for a soft copy, please do check our website. We do have our soft copy, the program,
Uganda omulimu gwe tukoze mu ife ng'abakyala. Kusooka kwa byonna byonna batuyambyeko okufuna justice obwenkanya buli mu nsonga dhaife dhe tuba naddo. Abakyala baba n'ebizibu aye nga bazira abayamba. FIDA etuyambye ni bwe muba mu kooti tulina abakyala.
Okay, the clerk has arrived, who will take charge of the courtroom. I understand the problem, the hypothetical problem was distributed. So for you to understand the deliberations, quickly read the problem question so that you understand the arguments being made by the teams. Yeah, and you're within context. So now without further ado, let me hand over to the clerk to do what he has to do.
Good morning. So first I will call out the judges of this court to take their seats. Yes. So we are starting with Judge Benon Makumbi. You're highly invited to take your seat. Yeah, then Her Worship Naigaga Wilfred Chobika. You're called out to take your seat. Then lastly, Judge Nivati Nandrija. You're called to take your seat. Before court starts and read the case. So I am going to give the judges each 1 minute to introduce yourselves before we start the session. Thank you. From me? Yes.
Good morning, everyone. All protocol observed. I'm called Nivatiti Nanduja, and I'm a product of Makerere Law School. And I'm really privileged to be here with you and to connect with other universities. I think that is a very safe space So thank you.
Good morning, everyone. All protocol observed. My name is Naigaga Winfred Chovika. I also am a product of Makerere University, and I sit on the feeder board. I'm glad to be here.
Good morning, everyone. All protocol observed. My name is Benon Makumbi. I'm a product of Makerere University, but I'll be a very fair judge. Yes, I'm a private practitioner, and I'm happy to be here.
Yes, we all rise. Court is now in session. The case in the Republic of Dakar, in the Court of Appeal of Dakar at Kianti, Civil Appeal number 0274 of 2024. Rita Izoma is the appellant, and versus Robert Okoye, who is the respondent. Judges take their seats, then the court can take their seats again. We can sit. Court session is on now.
Much obliged, your lordships. May it please this honorable court, for purposes of court record, my name is Joel Msiva, and I'm the lead counsel for the appellants, appearing jointly with co-counsel Elizabeth and co-counsel Chang Banda as counsel for the appellants. We have been allocated 30 minutes of this court's time, and we intend to use it in this line. I will be using the first 12 minutes to establish the case, and regardless of Rita being incurring in a lot of his energy in carrying in agriculture practices, she was always entitled to 20%, and Robert was always retaining the 80%. This, my lords, caused a number of family conflicts, which made the two to become counterparts in the home, my lords. However, the relationship wasn't in the year 2021, whereby the decision of the High Court, thus leading us to this appeal, my lords. My lords, the appellants therefore invoke the jurisdiction of this honorable court under Article 134 of the 1995 Constitution of Dakar, Section 66 of the Civil Procedure Act. This court has jurisdiction to hear appeals. This court has jurisdiction to hear appeals from the High Court. It has jurisdiction to maintain paragraph 10, paragraph 9 and 11. They built their home on this land, and they have been carrying out agriculture on this land for the last 16 years. My lords, I would like to put it to the attention of this honorable court that Millennium Webster Dictionary defines home to mean a place of residency. And such as the appellants, we believe that there is no dispute that this home is called, which was judged in between 1990 to 1994. Their lordship stated that contribution of matrimonial property is in two ways. There is indirect contribution and direct contribution. Indirect contribution being monetary, and direct contribution being monetary, and indirect contribution being...
Pardon me if I may read it verbatively. Conversion on the elimination of discrimination against women. Your lordships provide for the freedom from discrimination and the right to equality by both men and women at marriage, during marriage, and at its dissolution. Your lordships, my submission would follow a limb of argument which states that matrimonial property is divided based on the principle of contribution. Your lordships, The principle of contribution states that contribution can be either monetary or non-monetary. And the non-monetary part can be in ways of tilling land, looking after the children, looking after the sick. As I may persuade this honorable court by the case of Katuramu versus Katuramu, High Court number 19 of 2017, your lordships, your land brother, his lordship, Justice Wilson Musalu Musene, stated that contribution does not only have to be monetary, but it can be in other form, which include bathing the children, looking after the sick, feeding the family, your lordships, not forgetting.
Counsel.
Yes, your lordship.
This is a court of appeal and you're citing an authority from the High Court.
Your lordship, if I may answer.
Is that authority binding on this case?
Persuasive.
Persuasive, thank you.
Much obliged. To continue, as I was saying, the non-monetary, not forgetting, making love to the husband, which is a climax of a man's happiness on this world. Your lordship, paragraph 11 of the instant facts clearly states the appellant's non-monetary contribution, which included tilling land, looking after the children, paying some workers who gave her a hand in doing some of the house chores. Your lordships, all this indirect contribution, all this contributed to the well-being of the family, hence a contribution to the development of the matrimonial property. Your lordship, if I may persuade this honorable court more with the case of Joe versus Mbo Federation of Women Lawyers, FIDA, Kenya, petition number 11 of 2020, the Kenyan Supreme Court finding parties were entitled to a 50-50% share, observed that equity is an important principle when it comes to matrimonial property, since what was fair as related to equity was not a question of quantitative contribution by either each party, but rather contribution by any party in any form, whether direct or indirect. Your lordship, the appellant contributed to this matrimonial property indirectly. And if I may invite this honorable court to paragraph 10 of the instant facts, line 1 and 2, it is clearly stated that the couple started from scratch. The appellant is not a gold digger, as one may say, that she wants 50% of this property, but they built this from scratch because the land onto which they moved was filled with bushes and an old 2-roomed house. But they constructed a 5-roomed house in 2 years, and they constructed a vanilla plantation from which the family gained financial sustenance. Your lordships, if I may go further, under paragraph 17 of the instant facts, the respondent clearly states that the appellant was only doing all this as a woman. My lordships, this is very unfair to one party because this is a lot of work and this is overworking one party. My lord, if I may, this is also seen as a clear occurrence in the Republic of Dakala as stated by the 22nd National Household Survey that states that women spend 10 more years doing the unpaid care work rather compared to their male counterparts. This, your lordships, violates their rights because they are subject to overwork, your lordships. Yes.
Counsel, my understanding of your oral highlights in regard to the second issue is to justify why you're disputing the 20% award from the lower court to 50%.
Yes.
This court in its previous decision, has pronounced itself on the scope of Article 31. Article 31, Clause 1, Paragraph B of the Constitution of Uganda.
Yes.
Can you address this court on the principles that guide valuation of non-monetary contribution?
Your Lordships, if I may state, in this case, the trial land judge followed the principle of skill, attitude, and flexibility in doing all this work. And Your Lordship, in this, the appellant was physically working in the vanilla plantation. She could also do the good work at home, doing the chores, maintaining the order in the home, Your Lordship. That shows a good attitude and flexibility in doing all this work. Your Lordship, as I further submit, I'm requesting this Honorable Court to grant me 1 minute. I give a conclusion to my case.
Granted.
Much obliged, Your Lordship.
1 minute.
Much obliged. As I was submitting that distribution is based on the principle of contribution, Your Lordship, the trial courts disregarding the principle by requiring receipts, because there is no way one can provide receipts for taking children to school, provide receipts for tilling land, Your Lordship, provide receipts for looking after the children. This cannot, in a rhetorical form, my Lordship. How can one provide all such receipts for 16 years? They weren't married for one year, 2 years, nor 5 years, but 16 years, Your Lordship. As I give a cessation to this matter, I pray that the law protects women from discrimination and from overwork, as we pray as we bridge the gap of gender, as we bridge the gender gap, Your Lordship, and we pray that the trial court's decision be partially overturned. And with that, I would like to invite my co-counsel to submit on issue 3 and 4. Much obliged.
Much obliged, Your Lordships. For purposes of court's record, my name is Changu Agnes Banda. As earlier stated by our lead counsel, I will be using 10 minutes of this court's time to submit on issues 3 and 4. My Lords, issue 3 being whether the trial court's valuation of the appellant's non-monetary contributions in the form of unpaid care work on which her and the respondent's matrimonial home was situated contravenes legal provisions relating to the right to freedom from discrimination as well as right to equality in the Constitution of the Republic of Dakala. My Lords, quoting from Jennifer Okumuwengi in her book Women's Law and Grassroots of Justice in Uganda, that's on page 45, my Lords, she states that customary law fails to take into account the realities of married life in which spouses form a real partnership, that's in respect of their different but equal and complementary contributions to the welfare of the family. My Lords, going further, I would like to bring it to this honorable court that my arguments will be based on 2 strands of reasoning. The first being that the 20% distribution undermines the principle of equality, as well as the second being the 20% distribution discriminated against the appellant based on gender. My Lords, back to my first limb of arguments. The Black's Law Dictionary, 4th edition, on page 631, defines equality as a condition of possessing substantially the same rights and privileges, as well as being substantially liable to the same duties. My Lords, the same principle is equally enshrined in our Constitution of the Republic of Dakala under Article 31, which is to the effect that men and women shall have equal rights at marriage, during marriage, and at its dissolution. My lords, bringing it before this honorable court, in reference to paragraph 11 of the facts at hand, Rita and Robert both worked at this farm. It is quite evident that both of them worked at this farm. However, they had their different obligations, but just as Jennifer Okumuwengi stated, they are different, but at the same time, they are complementary to the welfare of the family. So when it comes to the dissolution, we're talking about equality. When it comes to the dissolution, my lords, Rita Izoma was granted 20%, whilst Robert was granted 80%, and we're talking about equality at the dissolution of marriage. My lords, bring to this honorable court that this distribution clearly undermines the principle of equality as outlined under Article 31 of the Constitution of Dakala. Furthermore, my lords, Article 14, Clause 2, Paragraph H of the Convention on the Elimination of Discrimination Against Women, which from henceforth I will refer to as CEDAW, acknowledges women's unpaid care work and calls upon state parties to consider this when it comes to matrimonial property distribution. My lords, proceeding to my second stand of reasoning, that the 20% distribution discriminated the appellant based on gender. My lords, Article 21 of the Constitution of Dakala, as well as Article 16 of the CEDAW, concerns many different facets of family life, both aiming at eliminating the discrimination against women, whilst providing equality at marriage, during marriage, and at its dissolution. And under paragraph 12 of the facts at hand, we see that Rita Izoma and Robert Okoye's marital disputes started from the time Rita wanted an increment from the 20% that she would be allocated, my lords. Bringing it into consideration that she gave a just reason, saying things had gotten expensive. And okay, honestly, that does not even show equality when it comes to marriage. My lords, proceeding to paragraph 17 of the facts at hand, still basing on this equality principle, Robert Okoye mentioned to say that Rita was only doing the duties expected of her as a wife. Before I indulge further into this, my lords, this is a clear contravention of Article 21 of the Republic of Dakala, which provides for freedom from discrimination, and in this basis, on the basis of gender. So Robert saying Rita was only doing that required of her as a wife, simply showing how much he undermined the principle of equality as well as discriminated her based on gender. My lords, still under paragraph 17 of the facts at hand, Robert said that daughters married into the Okoye family are not entitled to any portion of land. My lord, equally this discriminates Rita on the basis of gender as well as the repugnant clauses that are not allowed in this Republic of Dakala. My lords, this further brings us to the second ground of appeal, which states that the land trial judge erred in law and fact when he stated that the appellant is not entitled to 20% of the value of the property on which her and the respondent's matrimonial home was situated. My lords, under paragraph 19 of the facts at hand, it states, under paragraph 19 of the facts at hand, the land trial judge took cognizance of the fact that matrimonial property should be considered whilst dealing with matrimonial distribution matters. However, my lords, he did not indicate which market value he used to evaluate Rita Izoma's contributions. My lords, under paragraph 11, we see Rita's unpaid care work, such as tilling the land, should take children to and from school, she would graze the goats, collect firewood, do home chores as well as farm chores. All those are referred to as unpaid care work. I pray that this honorable court be persuaded by the case of Ambayo Joseph Wago versus Asariwa Jacqueline, civil appeal case number 100 of 2015, where it was stated that non-monetary contributions should be given a monetary principle so as to establish the market value at which similar services are offered. But my lords, the trial court's judge did not clearly indicate which market value he had referred to this, and hence arriving at his 20%. My lords, I pray this court be further persuaded by the case of Moot versus Ann, matrimonial cause number 20 of 2016, where Justice Mateka recognized the value of women's unpaid care work, especially with stay-at-home spouses, emphasizing the need of considering them when it comes to matrimonial property distribution matters. My Lord, it is therefore our submission that the 20% granted to Rita undermines her significant contributions that she had made towards the acquisition, or rather the development of that matrimonial property. Going further, my Lord, it is essential to note that unpaid care work is necessary when it comes to matrimonial distribution, as well as granting her this 20% discriminated her as well as perpetuated gender-based discrimination. Going further...
Counsel?
Yes, my Lord.
You're saying that the 20% was unfair. What
Yes.
would be fair?
A 50% share, my Lord.
Have you looked at the fact that when the marriage was beginning, the gentleman came into this marriage with the land?
Yes, my Lord.
All right, continue.
Thank you so much for that question. Just to justify on that, the gentleman might have come into land, but referring to the Supreme Court case of Julius Ravinumi versus Hope Bahimbisomo, which I pray this honorable court be bound, it was stated that the court should also consider contribution of both spouses when it comes to division of matrimonial property. My lords, on issue 4, on whether the appellant is entitled to the relief sought, according to paragraph 20 of the facts at hand, it was the appellant's prayer that the trial court's decision be partially overturned and that she is granted either 50% of the property or 50% of the value of the property on which her and the respondent's matrimonial home was situated. Therefore, my lord, I pray this honorable court be bound by the Supreme Court case decision in the case of Julius Ravinumi versus Hope Bahimbisomwe, where court has gone ahead to grant a 50% split and stated that this should be contingent on whether the claimant can prove contribution towards this property, and similarly also in the persuasive case of Moot versus Anne, where court had gone ahead to grant a 50% distribution. My lord, it is our submission that the appellant should be granted 50% of the value of the property on which her and the respondent's matrimonial home was situated, and therefore that the trial court's failure to award 50% perpetuates gender-based discrimination and is in contraventions with legal provisions in our Republic of Dakala. My lords, therefore, we as the appellants have the following prayers: that 1, this appeal be allowed without costs, taking into consideration that this is a family matter, my lords. In as much as these marital disputes have emerged, we pray that this honorable court take into consideration the harmony and development between the two families. The second prayer is that the judgment of the trial court be partially overturned, and lastly, that the appellant is granted either half of the property or half of the value of the property on which her and the respondent's matrimonial home is situated. My lords, we so submit. Counsel for the appellant.
Much obliged, my lord. For purposes of court record, my name is Mwine Andrew, appearing on behalf of the respondent, Mr. Robert Okoye, and with me is co-counsel Mutesi Sandra and co-counsel Faith Kakoza Nabakoza. My lords, I'll be using 10 minutes of court's valuable time to handle issue 1. My co-counsel, Mutesi Sandra, will be using 12 minutes to handle issue 2 and 3 respectively. And lastly, my co-counsel, Faith Kakoza Nabakoza, will be using 5 minutes to handle issue 4 and thereby conclude. My lord, we concur with the appellant on the issue of jurisdiction of this court, and therefore pray that I proceed, my lord.
My Lord, this matter arises from the dissatisfaction of the court decision in Konde High Court, divorce cause number 034 of 2022. My Lord, here are the facts. The couple, the appellant Rita Izoma and the respondent Robert Okoye were married for 16 years. In that marriage, they came up with disagreements and misunderstandings that resulted into a filing of a divorce by the appellant on grounds of cruelty and adultery. My Lord, when that happened, the court indeed ordered for a divorce and went ahead to order for custody and maintenance, but not ordering the fact that the appellant can get half of the property and half of the value of non-monetary contribution indeed dissatisfied the appellant, and that's why we are here, my Lord, to argue this case once again and prove to the court that indeed the trial court did not err in law in any of the grounds that are presented by the appellant. My Lord, let me go further to present the summary of arguments. In issue 1, my Lord, we are going to present aggregated evidence that indeed the trial court not awarding 50% of the property on which the matrimonial home is situated did not in any way contravene the rights that are indeed claimed to have been contravened by the appellant. In issue 2, we are going to provide aggregated evidence to your satisfaction as this honorable court that indeed not awarding 50%.
Council Mwine,
my Lord,
don't tell the panel what you intend to do.
Much
Just
obliged.
dive into your oral highlights.
Much obliged, my Lord. Going on further, in issue 2, we are going to present to this court and we are going to argue that not giving 50%.
Council Mwine, go straight to your oral highlights on the first issue.
Much obliged, my Lord. Let me delve into issue 1. And this issue states that whether the trial court's decision that the appellant is not entitled to the property on which the matrimonial home is situated is a contravention of her right to freedom from discrimination, her right to property that is provided for in the Land Act and in the Constitution of Dakala. My Lord, it is our averment that the reality remains that when there is divorce, and indeed the ship has gone into the rocks of marriage, my Lord, the hard situation of distribution and division of matrimonial property steps in. But my Lord, this hard thing cannot aver that we consider love, we consider romance, or we consider the relationship, but indeed consider fairness and justice. Going further, my Lord, the Constitution of Dakala under Article 237, my Lord, envisages that indeed the land is indeed given to the citizens, and they hold it under the customary tenures, the tenures that are provided. Inter alia is customary land tenure, which is communal, my Lord. The Land Act and the Constitution of Dakala does not automatically entitle any of the spouses' property because of merely living together, my Lord. We therefore arm ourselves with the case of Rabinumi versus Bahimbisomwe. My Lord, in this case, they defined matrimonial property by adapting the case of Chintu versus Muwanga, my Lord. And they indeed said that this is property that is jointly contributed to by the couple. Furthermore, my Lord, regional statutes have also averred on the same matter and have aggregated responsibility to different states. And I beg leave of court to read Article 7D of the Maputo Protocol. I go ahead. The article says, states parties shall ensure that in case of separation, divorce, and annulment of marriage, my Lord, the right to unequitable sharing that is derived from the marriage should be jointly aggregated. We therefore aver, my Lord, that the land on which the matrimonial home is situated, my Lord, is not in any way a property of either the appellant nor the respondent. Therefore, we conclude, my Lord, by saying that, indeed, there cannot be a court that will aggregate this property as marital property if indeed it is not owned either by the appellant and the respondent. We also, in the facts, my lord, paragraph 9, look at the fact that indeed, this matrimonial property at the eve and the inception of their marriage belonged to the clan, and therefore the respondent was holding it in trust for the family. We therefore say, my lord, that indeed the trial court not to give this property and apportion it as matrimonial property was indeed proper in law, both at law and at equity. My lord, going further, equity looks at substance rather than form, my lord. My lord, when equity looks at a matter, and indeed it is inclined at form and not substance, it takes that matter as inequitable, my lord. And this court is bound by section 14 of the Judicature Act, where it spells out that as courts are handling matters, they apply both common law and equity principles in order to decide the matter. Therefore, my lord, we aver that allowing this property to be dealt with as matrimonial property defeats equity, because we would have taken form other than substance, my lord. Furthermore, my lord, Article 26 of the Constitution of Dakala.
Counsel.
Yes, my lord.
Are you trying to say, no, I just wanted you to highlight to the court, when the clan allowed the couple to build a house on this land, what can court term that treatment?
When the clan gave the land to the couple, it gave them user rights, but it did not aggregate ownership to them.
Even to the extent that they built a house, a permanent house on the land?
Yes, my lord. They are entitled to use it for as long as they can, since it is communally owned, but they cannot entitle themselves in terms of ownership. Much obliged, my lord. Going further, my lord.
Counsel, before you proceed, do you have a copy of the revised Land Act? Because you cited the Land Act in your introductory remarks. Do you have a copy of the Land Act?
We do.
Can we go to section 3 on the incidence of customary tenure, especially subsection 1, G?
Much obliged, my lord. Should I read it?
You don't have to read it. Now I'm asking, are you still maintaining your argument that individual subdivisions are not feasible under customary tenure?
Much obliged, my lord.
Are you still maintaining your argument?
I indeed take the correction, my lord.
Are you still maintaining your argument, or you abandon your argument?
I take it as a matter of correction, my lord. Much obliged, my lord. My lord, it's an established principle in law, nemo dat quod non habet, which literally interprets that no one can give what they don't have, my lord. In this instance, and according to the facts, my lord, this land does not belong to the respondent, and therefore cannot give what they don't have, my lord.
Counsel, you're contradicting yourself. You abandon that line of argument in light of the statutory provision on subdivision for individual ownership under customary tenure.
My lord, on that argument, I would like to aver that this land is not owned in subdivision, but in its entirety as a whole by the clan.
But the fact that they went ahead and constructed a new house, yeah, after that arrangement, be it an ancestral conversation, they constructed a beautiful house from the small house they had. That had serious implications which you need to consider in your submission.
Much obliged, my lord. Therefore, my lord, as I conclude my issue, it is our averment as the respondent that indeed the award of the High Court, the High Court decision not to award 50% of the matrimonial property on which the matrimonial home sits, my lord, is not in any way contravention to the appellant's right to own property, nor is it a contravention to the right to freedom from discrimination, my lord. I beg to yield ground to my co-counsel to handle issue 2 and 3. Much obliged, my lord.
Much obliged, your lordship. For purpose of court record, I am Counsel Mutesi Sandra, appearing for and on behalf of the respondent, Mr. Richard Okeye, in this matter. Your lordship and lordship, I'll be substantiating on issue number 2 and issue number 3, respectively, and I'll use 12 minutes of this court's time. I beg to proceed with issue number 2. Your lordship, issue number 2 states that whether the trial court's decision not to grant the appellant 50% of the value of the property on which her and the respondent's matrimonial home was situated on account of the fact that she did not adduce documentary evidence in form of receipts is in contravention of the legal provisions relating to the right to freedom from discrimination, the right to equity at marriage, during and at its dissolution. Your lordship and lordship, in answering this issue, allow me re-echo that the facts per page 8, paragraph 18A of the case question are clear to the extent that neither the appellant nor the respondent owned the land on which they were situated for the past 16 years of their marriage. Your lordship, this coupled with the fact that the appellant has even failed to meet the threshold of presenting evidence in form of receipts defeats her claim of entitlement to a 50% value share. Your lordship, from section 101 of the Evidence Act, cap 8, it is clear to the extent that whoever, your lordship, that whoever desires any court to adduce, any court to give judgment as to any legal right or liability dependent on the existence of the facts which they assert, they must present evidence to prove those facts. Your lordship, this read in tandem with section 102 of the Evidence Act still, which says that the person who bears the burden to prove her case is that who will lose if no evidence is provided. Your lordship, it is from this that we demand that the appellant should adduce evidence in form of receipts to prove her claim of entitlement to a 50% share. Your lordship and lordship, furthermore, it is the rule of the thumb that the appellant must prove contributions towards matrimonial property, as was mirrored in the famous case of Mwanga versus Chintu, divorce appeal number 135 of 1997. Your lordship and lordship, the trial court's decision not to grant the appellant a 50% value share is not discriminatory in any way, as the trial court's arrival at its ruling was solely based on facts presented. The mere fact that the appellant failed to prove her claim is what the court based on to assess that she was not deserving of a 50% division. Your lordship and lordship, we further persuasively rely on Article 21, Clause 3 of the Constitution of Dakala, which goes ahead to define discrimination as to give different treatment to different persons attributably and mainly to their respective descriptions such as sex, age, color, ethnicity, birth creed, among other things. And we contend that the trial court's decision was attributably given based on fact and law. Your lordship, may this honorable court be passed. Yes, your lordship.
Before you continue quoting the Constitution, I just wanted us to just have the basics. Do you agree that there was unpaid care work
yes,
in
your
this
lordship.
situation? So why would you be asking for receipts on unpaid care work?
Much obliged, your lordship. Your lordship, the issue number 2 that
Which kind of receipts do you want? For what contribution?
Much obliged, your lordship. Your lordship, issue number 2 is attributably asking for receipts showing her contribution to the building of the property because she wants a 50% share of the property.
Of the bricks and the cement and that.
Yes.
All right.
Much obliged, Your Lordship. May this honorable court further be persuaded by the celebrated case of Ambayo Joseph Waigo versus Jacqueline Aserua, Civil Appeal number 100 of 2015, where it was stated that equality of spouses guaranteed by the Constitution is not synonymous with equal property entitlement and does not give automatic half share to the couples. Your Lordship, to conclude on this issue, may it be noted that the appellant's claim of discrimination as a result of the trial court's decision not to grant her a 50% share of the property lacks merit. We therefore pray that this honorable court upholds the trial court's decision. Much obliged. I beg to proceed with issue number 3. Much obliged, Your Lordship. Your Lordship, issue number 3 of this case states that whether the trial Julius Rabinumi versus Hope Bahimbisomwe Civil Appeal number 100 of 2009. Your Lordship, in this case, it was held that non-monetary contribution must be valued against monetary contribution made by both spouses. It is from this basis that this comparison was made by the trial court and they arrived at a 20% share. Your Lordship and Lordship, 0 and 20% are two different things. It's not that her contribution was not solely recognized, but rather it was recognized and the trial court saw it deemed to award her a 20% from the unpaid care work, Your Lordship. Your Lordship, Article 31, Clause 4, which guarantees equality at marriage, during, and at its dissolution. This equality, Your Lordship, does not mean an automatic 50 by 50 division, where contributions, monetary and non-monetary, juxtaposed to each other, were not equal. Your Lordship, may this bench move with me to page 14 of our written submission, where we persuasively rely on the case of Mayambala versus Mayambala, divorce cause number 3 of 1998, where following a successful petition by the wife, the court ruled that the wife was deserving of a 70% share. Your Lordship, from this case, we clearly see to a conclusion, which is contrary to the case at hand, as the appellant has failed to prove her claim of entitlement to 50% rather than the trial court's decision of 20%. Your Lordship, from the above case, still we look at that equity does not mean an automatic 50 by 50 division, but rather it's ensuring that everyone has the same rights and opportunities, and therefore we should differentiate between equality and sameness. Equality looks at fairness, whereas sameness looks at uniformity. Your Lordship, it is from this that we see that the appellant is looking for sameness, which promotes uniformity. Yet, the courts of law must look for fairness. Your Lordship, in this case, the trial court balanced both forms.
Before you leave that point,
yes, Your Lordship,
I believe that non-monetary contribution in terms of tilling the land, in terms of washing the clothes, in terms of looking after the sick, all that can be commensurate to a financial figure in this case, of which that needs to be considered as you're doing your submission on that issue.
Much obliged, Your Lordship. Your Lordship, based on the fact that the appellant, number 1, that this appellant failed to adduce evidence. Number 2, that this appellant used to enjoy a 20% from the proceeds of vanilla, and the vanilla that was cultivated on their family land, shows that she was not solely left to do the work all by herself, remembering that the facts are clear to the extent that she even hired people to help her do this work that she's saying that she spent 10 hours doing. She used to hire people on the money that she used to get from the proceeds of vanilla. Your Lordship, it is It is further argued that on the balance of both forms of contributions, that is monetary against non-monetary, that the trial court found that a 20% valuation was a fair and just given to the appellant. We therefore pray that this honorable court upholds the trial court's decision and allow this appeal to stand.
Counsel, at page 12 of your submissions, your memorial, you cite this court's decision in Mbayo Joseph versus Jacqueline. And that case is quite instructive on valuation of non-monetary contribution. And you also acknowledge, according to the evidence on record, that there was active involvement of the appellant in the activities. Now the question from the panel is that, is it possible to monetize those services for purposes of weighing her contribution against the respondent's direct contribution to the project?
Much obliged, Your Lordship. Yes, Your Lordship, it is very possible to weigh the non-monetary contribution.
And was that assessment conducted by the trial court?
Yes, Your Lordship. Much obliged, Your Lordship. I beg to re-echo that we pray that this honorable court finds that on the issues that the appellant have found, they lack merit and therefore should dismiss this case and allow the appeal to stand. I therefore beg to relinquish ground for co-counsel to submit on issue number 4. Much obliged.
Much obliged, Your Lordships. For purposes of court record, once again, my name is Nabakoza Faith Kakoza, and I'll be submitting on the last issue, which states that whether the appellant is entitled to any relief sought. Your Lordships, the appellant desires that a share of property be granted in regards to where the matrimonial home was situated, and indeed the trial judge in that moment was erroneous. However, it is important to re-echo this to this honorable court and satisfy itself what then amounts to matrimonial property, because this court has no any indulgence in any property that is not matrimonial property. At the moment of dissolution of marriage, courts are only concerned with what amounts to matrimonial property. In the case of Julius Farabinumi versus Hope Bahimbisowe, Civil Appeal number 100, as clearly echoed by both sides of counsel, it states that matrimonial property, Your Lordships, and I want us to be specific and particular to those words, that matrimonial property should be treated differently. Your Lordship, matrimonial property means different things for different people and applied in different contexts. I beg to read it verbatim. Your Lordship, it says that matrimonial property is understood differently by different people. There is always property which the couple chose to call home. There may be property which may be acquired separately by each spouse before or after the marriage. Then there is property which a husband may hold in trust of the clan. Each of these should, in my view, be considered differently. That was the decision that the case upheld as the decision that was arrived at by Justice Bosa J, as he then was. The matter at contention right now is the property that was held in trust of the clan on behalf of the respondent. I beg this honorable court to be clear to that we are not handling any other property, but that property that the respondent held in trust of the other. What that means, Your Lordship, that when you hold property on trust, you do not hold it as a legal person. You hold it as a person, as a trust, Your Lordship, for the beneficiary of others, Your Lordship. It therefore follows that the trial court indeed was right and was just by holding that this property does not amount to matrimonial property and therefore could not be even subject to discussion in this honorable court. It therefore follows, Your Lordship, that the trial judge indeed was right and did not occasion any miscarriage in justice, and that court should not allow the appellant to be granted that share, because then it will be erroneous and it will cause another miscarriage of justice. Your Lordship, the appellant also seeks to be granted 50% and claims that the trial judge erred by failing to put, by requiring the appellant to give in documentary evidence, Your Lordship. The matter in contention, I want to be very clear to the extent that the issue is concerning receipts. Your Lordship, receipts are documents. Receipts are documents. So there is no way you can prove a receipt on oral accounts. I'm alive to the fact that evidence can be proved by oral accounts or documentary evidence, but the courts are only bound by evidence. And in this case, where the appellant is required to adduce documentary evidence, was and at all times required to give that evidence in terms of documents. The best evidence rule in regards to documents, Your Lordship, under Section 61 of the Evidence Act, Cap 8 of Dakala, is clear that evidence is best proven if it is the primary document itself adduced to the court. If she claimed a contribution in regards to the home that was built, because if you've participated, technically, a woman who wants to have a share, you take the due diligence to acquire those receipts. So if the dissolution of marriage accrues then it is incumbent on you as a duty for the plaintiff or the appellant to prove.
Counsel Faith.
Yes, Your Lordship.
You're asking this court to ignore the reality of how men and women operate in this country in intimate relationships. Is a spouse expected to document every receipt for everything they do in the household?
Well, Your Lordship, maybe if this Honorable Court would like to state that spouses are different from other human beings. Because before your spouse, you are a person. The laws of Dakala accrue to everyone, irrelevant of their marital status. If the Evidence Act is clear that who alleges, and the best evidence rule in regards to documents, the documentary evidence, that is irrelevant of your status of being married or a single person. Your Lordship, it therefore follows that trial judge was indeed right by failing to apportion that property because no evidence was granted. The appellant also seeks that she should be granted.
Counsel, are you trying to say that the respondent was holding land in trust for someone?
Yes, Your Lordship.
Who is that person?
The clan members that belong to the family of Okoye.
Are they legal persons under the law? Who is the clan?
Well, because now we have to devolve into issues of customary law, and in particular customary tenure. Your Lordship, customary tenure being introduced under Article 237 of the Constitution of Dakala, it grants powers that the law in that place shall govern customary tenures, unless to the extent it is inconsistent. Since court has been indulging me, I beg for more time.
You have 1 more minute.
Yes, Your Lordship. So the customs of Dakala to that extent are that this property, Your Lordship, it doesn't even accrue in per se that to the people sitting on this land. They only have user rights, which the appellant was also given, rights to cultivate, rights to build, but it doesn't mean the equity for generations that would come. Or the other issue that the appellant seeks, that she should be granted 50%. Your Lordship, it is clear to the extent that just like adopted in Rabinumi Supra, Waki Azengo in the case of Kenya clearly stated that a dissolution of marriage or equality in regards to Article 21 does not per se mean equality in dissolution of property. And it states that matrimonial property must be proceeded not on the basis of love, not on the basis of affection, but courts must at all times put into consideration and weighing circumstances of the particular aversions of the party, Your Lordship. It therefore follows that this court may continuously occasion a miscarriage of justice by occasioning its judgments in regards to affection, because even the respondent in this case was hurt if we are to base on affections. But if we are to base on the law and facts in this case, the trial judge did not err at all, and we pray that the appellant is not granted in any of those reliefs, and this case be dismissed with costs to the respondent. I beg to submit.
Much obliged, Your Lordship. My name is Joel Msiba, once again, and I will be giving rebuttals for the respondents in our 2 minutes. My lords, the respondents have been giving rebuttals, and on the first issue, they relied that this land is customary, whereby they have to follow customs of this clan. My lords, I want to put it attention of this honorable court that Article 2 of the 1995 Constitution of Dakar states that any custom which is in contravention of the Constitution is null and void. This custom was under paragraph 13 of the facts at hand. The mother stated that in Tonga clan, the lady could not get anything. Then in paragraph 17, Robert stated that they cannot give land to any person who is not who is born in this clan, whether is that person is a daughter, or they cannot give it to a lady who is just married to this clan. My lords, it's our submission that this is contravening with Article 21, Article 31, and Articles 26, whereby Article 21 provides for equality, Article 26 provides for a right to own land, which is being denied by the appellant, and Article 33 provides for 31 provides for equality of men and women at marriage, during marriage, and at its dissolution, my lords. My lords, now, the respondents stated that equality looks at substance rather than form, forgetting that equality follows the law and equity is equality. My lords, furthermore, under issue 2, they responded that the appellant did not provide documental evidence. However, we submit as the appellant that documental evidence is not the only evidence which court can rely on to make a conclusion. Under section 58 and 59 of the Evidence Act, Cap 8, they provide for oral evidence. And in paragraph 17, Robert also asserted it that the appellant was carrying out these jobs, but he made a statement that she was only doing this because she was a lady. That is a discriminatory act. My lords, furthermore, they relied on the case of Kagwe versus. I pray that this honorable court grants me a minute. I conclude my rebuttal.
Granted.
My lords, furthermore, they relied on the case of Kagwe versus Kagwa, which they relied on the case of Mwanga versus Chintu, which defines what matrimonial property is, stating that this land is owned in trust of the clan by the man. However, my lords, this land is looked at as home by the appellant and respondents, and it was defined in the very case. My lords, furthermore, once someone stays on land for more than 12 years uninterrupted, he or she has a right of taking over that land. And in these facts at hand, it's nowhere that it is provided that the clan members gave this land to Robert and Rita. However, they just settled on this land, and in the 16 years they have stayed on the land, they have never been interrupted. My lords, furthermore, when they were responding on their last issue, they stated that in the case of, my lords, I so submit counsel for the appellant.
There is no rejoinder from Elizabeth and Kangu.
Court session is done. We all rise. As a norm, the two parties will shake hands as the judges get out for a moment of break. Thank you.
Okay, as our councils shake their hands and our Lord judges depart to their judicial corner or room, we want to thank you all for the participation and really being a very good audience. Maybe we forgot to mention in the morning that actually the two ladies on the bench are actually your worships. They are magistrates of the court. And then the gentleman is a legal practitioner. But in the afternoon, we shall have judges from the court, the High Court, coming in to preside over the final rounds of the Moot. So please be around as well. Now we are going to break for tea. Please have your tea quickly, maybe about 15 minutes, and then return for the second round of the semi-finals. After this, we determine the team that will Moot in the final team that will Moot in the afternoon. Thank you very much. The technical team, you can continue to show us the montage and some bit of music as we enjoy the break. Thank you. Thank you also to our sign language interpreters. For all those in need of signage, our sign language interpreters are here to assist you. Okay, take a 15 minutes tea break. Tea is served outside. All our lecturers from the other universities and coaches, please, you will have your refreshments in the Huripek room. There is a special place there for you with the judges. The deans, principals, and coaches from the other universities, please, the room is right there where you will have your refreshments.
I'm too addicted to hauling a sente. Tally con expiry date. Pulika seranja galambe wendi. Jangu, come a little bit closer, baby. Sembera, wameza netejo. Sita kuveyo, chakala kuveno. Ntekeyo, awo. Sita kuveyo, chakala kuveno. Ntekeyo, oyo, oyo.
Ladies and gentlemen, let's please come back in. We are running out of time. If you have a cup of tea in your hands, please you can come back in with it. A gentle reminder not to litter. Please do use the dustbins that are availed. Leave the plate and the cup at the serving area when you're done. Ladies and gentlemen, let's move back in, please. We are running out of time. If you've served tea, you can comfortably walk into the room with it so that we can continue with the program.
Panicking and putula. Tell me now, love panicking if I were. Panicking and putula.
Excuse me, if you have a snack in hand, please walk in with it. If it's a bottle of water, tea, walk in with it so that we continue with our program. A gentle reminder not to leave any littering, please. Use the dustbins that have been provided to ease the work of those that will be cleaning after us.
Let me keep your secret check. Deepest of my heart is the safest place. So baby, turn to me and say, hey.
The teams that are near the registration desk, kindly get in. Ladies and gentlemen, let's not please stay at the serving areas. Let's come in if you have a drink and a snack. Good afternoon, ladies and gentlemen. Welcome back from the first part of the agenda. I have been alerted that the teams are going to switch. So the team that was here is now going to go up and battle it with another team up. So here we'll have Team G and Team C. So Team G and C, the name tags are going to be put again. But we'll have Team G here and then Team C here. And then Team A and D will be going up.
Viola. timutumide bambi omuwena kafananyi ako bambi alabengako bayona mbenga kumeme nange mubenga kumeme alina kabiri bayola akayoyo bambi okokosa kayindo akalalo koswiti wenzejukira erinnya lye okulyogera mpomerwa kozinde konungansani kozinda nunga lirise obulire nti bulaya abawala bangi abalungi ekyo tekimutiisa bayola malayika wange mama bayola mwagala kampa bayola akumendika kubaga nange nendi mukomendo wesigwa la 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 la. La 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 la. La la la. Muwulire nti ebulaya abawala bangi abalungi ekyo tekimutiisa bayola malayika wange mama bayola mwagala nyamba bayola munange munange oli mukwano gwange kwagala nnyo byonkoledde si bitono ndikutiza wontya omanye nti babi byonkolera bisima ddala bambi omukwano gwaffe bambi tegusobola nze kuntama amazima
Hello.
Let me just read. All right, we are now settled in, ladies and gentlemen. So for the next session, we are going to have all right. So the teams are going to switch up. Those that were appellants before are going to become respondents and make their case in this court. And then those that were appellants up are going to switch up and become respondents in that other court. And in that regard, that means in this particular courtroom, we're going to have Team G and Team C. Earlier, Team C was an appellant in the earlier session. So right now, they are going to become respondents, where we have Team G come in here and then be the appellants. For courtroom 2, the appellants earlier were Team A, while the respondents were Team G. Like I've already said, Team G is moving here, and therefore Team A will be moving up and becoming the respondent, while Team D is becoming the appellant. Those are many words, so let me just read it for just some clarity. In this particular boardroom, we are going to have Team G as appellants and Team C as respondents. In courtroom 2 on the White House, we are going to have Team D as appellants and then Team A as respondents. If any of these teams is what you are supporting, please feel free to move to the room where that team is. I just thought that we'd convene here before, get instructions, and then we can do that next session. The next session is going to take strictly an hour. I'm going to request that we use the next 5 minutes to move to the rooms, because earlier we suffered a challenge with the starting time for the team up. For us to be able to cover that time, let's kindly use 5 minutes beginning now to allow us move to the other side of the White House. So if your team is Team D and Team A, we are going to be up in courtroom 2. Let's kindly use 5 minutes so that we do not keep you longer. Team G is the appellant here, and then Team C has moved to become the respondent. Please feel free to follow your teams to the rooms where they were. For the feeder teams, please, those that were up taking charge of the courtroom 2, kindly also move there to support the judges on the proceedings. End of announcement. Let's kindly move for those that are moving so that we begin the next session. In the next few minutes, we'll be ushering in the judges. The judges have also switched up a bit to allow for learning. So do not be surprised if the judges are different from the ones you saw in the morning session. IT, you could play some videos from FIDA in the meantime as we organize ourselves to the next session. Kindly feel free to follow your teams for courtroom 2. If you're Team D, Team A, we are up in courtroom 2. If we are set, just allow me alert the clerks to have the judges come in so that we start. Are the teams ready? All right, Team G and C, are you ready? Perfect.
Ladies and the few gentlemen that are in the room, we have seen the power of dreaming, the power of collective creativity. Today we celebrate with you how far we have come. We celebrate all the small and the big successes.
Of course, we have moved from place to place. We have been squatting different homes. I'm happy that finally we have our own home here.
I stand here on behalf of the current board, first of all to thank God, who has brought us here to witness this momentous event, that we actually do have a home. The Reverend mentioned it, that for some people they just walk in, to a bank and, just cash down. But for FIDA, it's been a journey and a long, painful, hurtful journey, but we have made it and we are here.
When one time I was going to elections, there was this woman and she went around saying, this woman brought FIDA and you are suffering, you men, you are suffering. And the men rose up against me because I brought FIDA. So they said, we are not giving Matembe a vote because she brought FIDA. And now I said, when I stand to campaign, I say, okay, I understand. Because of FIDA, you are not giving me your vote. That's very good for me. Because when I go to Kampala, I don't have much time to spend here. So now if you don't send me to Parliament, I will sit here in FIDA and I will make sure every time I'm around and I will reach you there. And then they said, this is bad. She would rather be away and be a little while here.
Gratitude is its own energy field. When you are grateful for whatever you have, it allows for more to be granted to you. And it changes the way you experience life. Grace is transformative. The more grateful you are, the more grace mirrors the gratitude you have. That's a quotation from Oprah. I'm a die-hard fan of Oprah.
God has been gracious to you. That finally we have a house here, a home, which is, it will lead into the other dream.
So I'm really happy that you invited me for this 50 years anniversary. I didn't think it is so long, but apparently it is. So I want to congratulate you, congratulate all of us, and wish ourselves the
This is the day that the Lord has made. Hallelujah! Amen. Praise the Lord! Amen.
You as a friend, and I have lived in the goodness of God. And all my life you have been faithful.
We are all locked up. There's nothing much to do. Facebook was locked by the government, so this is the only app that we can freely access and interact with people that we don't know personally, because the other apps are really personal. So when I first got onto Twitter, I didn't know how it works. I didn't know the rules that people have set for themselves on the app, how it's a very violent app, very volatile. There's a lot of things that can happen. Things change quickly. It's a fast-moving app anyway. My name is Olivia Winter Karunji. I'm an engineer by profession. I am a business owner. I co-founded Eco Options. That is a business that generally sells eco-friendly menstrual health products. As someone who supports women's rights, I will always stand up in case I feel like someone is being stepped on, tramped on, or someone is giving a view that shouldn't be given, because we can't be spreading misogyny in this country. I am a woman who speaks. Of course, there is a lot of backlash from especially men and some women, but especially men, who think your views don't matter or your views don't align with theirs. So the best way they can do it is insult you, body shame you, try to pull you down. We need to talk about the things that are wrong so that other people tend to see that they are wrong. Because sometimes it's ignorance and sometimes people just don't want to hear it, or if they hear it many times, it will stick into their heads. And for that, I'll give an example of recently. So recently, I think a chef was having an outburst with a certain gentleman. And someone's comment about the situation was, but she belongs in the kitchen. And of course this can be a plain statement and people will take it like it's a chef, but this is a woman. So if we are saying a woman belongs in a kitchen, that's a misogynistic statement, because what do you mean by she belongs in a kitchen? So that's something that you call out and you say this is very misogynistic. You have to speak up on the things that you see wrong. Like, we know everyone has to fight their own fight, fight their own battle. But then if you see someone is doing something wrong, I think first of all you have to call it out. You can't let it go and just let it slide because you don't know the person. If it's something wrong, you have to call it out and tell them that this is wrong. And then maybe as a person who has been affected, you can protect yourself, because you can protect yourself, one, by muting the conversation and excluding yourself from it. Of course, some people will say, oh, that's being a coward, but it's what is good for you, so you have to do what's best for you. Two, you can protect your account by limiting the number of people that can access it. Of course, it's not what you would want, but sometimes you have to create measures that will suit you and help you as a person in that moment. The internet is a very wild place, and you'll find very many different people who you literally do not know where they have come from. As you use the internet, learn.
Civil Appeal number 274 of 2024. Rita Izoma, the applicant, versus Robert Okoye, the respondent. I'm Elizabeth Abasa, and I'm the bailiff of this court session. We sit. Court session is on.
Counsel, you ready? May you address the court?
May it please this honorable court, I am Counsel Amanya Belinda, appearing with Counsel John Isaac Ochuo and Counsel Nakalule Hajara from M&S Legal Aid for the appellant. Your Lordships, the respondent is represented by Counsel Musiba Joel, Counsel Banda Agnes Changu, and Counsel Katusime Elizabeth. Your Lordships, I request to proceed. My Lordships, the matter before us today arises under, I beg your apologies. My Lordships, the matter today arises from divorce cause of the High Court of Dakala 34 of 22, arising under Article 134 of the Constitution of Dakala, Section 66 of the Civil Procedure Act of Dakala, and Section 10 of the Judicature Act of Dakala, thus granting this honorable court the jurisdiction to hear the matter before us.
Counsel, you didn't stipulate the time you're going to use to allocate yourself.
Most obliged. My Lordships, we have been awarded 30 minutes. I will proceed with the first 10 minutes. My co-counsel will proceed with the next 10 and 7 respectively, and the remaining minutes will be reserved for our rebuttal. Thank you.
Proceed.
My Lordships, 88% of the women in Dakala, compared to 78% of the men in Dakala, are engaged in the informal sector. These same women are expected, or in turn offer, extra 10 hours of their day's time, even when it is outrightly known that a normal human being only has 24 hours. But however, at a time of dissolution of marriage, their valuable contribution is always neglected, is never valued, but they're thrown away like camels after they have served the purpose and the work of their masters. Your Lordships, this honorable court has been given the power, the mandate to reinstate the position and value of the contribution made by women, and more to that, their right to own property, especially in matrimonial cases. My Lordships, the matter before us is a matter of a one Rita Izome, a woman that has been married for the past 16 years to Robert Ikoye, dedicated her energy, her resources, her devotion to the betterment and growth of her family. But at the time of dissolution, it happens that the trial court holds that all Rita Izome is entitled to is 20% of her non-monetary contribution, and that she does not have ownership to the property in question. My lordships, I request to proceed. Your lordships, the appellant arises under 2 grounds that were raised in the High Court. However, during the scheduling conference, the parties agreed to 4 issues, and I will proceed to resolve issue 1. Issue 1, which states that whether the trial court's decision that the appellant is not entitled to any share of the property on which her and the respondent's matrimonial home was situated is in contravention of the legal provisions relating to the right to freedom from discrimination and the right to property in the Land Act and the Constitution of the Republic of Dakala. My lordships, I will proceed to resolve this issue under 2 head arguments. Argument 1 being that Rita is a rightful member of the Okoye family and thus entitled to a share of the property. Argument 2 being that the trial judge used customary law, which to the extent to which I will be submitting is inconsistent with the Constitution of Dakala. Proceeding with argument 1. Article 31 of the Constitution of Dakala speaks to equality at marriage, during marriage, and at the dissolution of marriage. Article 26 proceeds to speak to the ownership, to the right to ownership of property, whether jointly or individually. My lordships, in the case of Wenman versus Ash, case of 1853, it was held that when man and woman get married, they become one. In paragraph 1, we are referred to the fact that 84.5% of the people in Dakala are Christians. And in paragraph 9, that Rita Izome and that Rita and Robert happened to be Christians and were married in a Christian religion. And according to the Christian norm, it is known that when man and woman get married, they become one. And to that extent, in the case of Nachinji versus Melchizedek, case of 1978, it was held that a husband holds property in trust of the wife. But we do not end there with our argument and proceed to say that in the case of Ambayo versus Asenua, it was held that monetary contribution and non-monetary contributions should be valued and in turn create ownership or a claim of a property to the parties that contribute to the property. In the case of Hawa Mohammed versus Ali Seifu of 1983, it was held by the trial judge that contribution to property makes one entitled. According to the facts at hand, it is well established that Rita Izome, under paragraph 10 and 11, participated in the clearing of the land, participated in the building of the 5-bedroom house in which they live in, participated in the tilling of the land, managing, harvesting, selling the vanilla, managing the home and family, and also house chores, which are both monetary and non-monetary contribution, and therefore make her party and entitled to be a member of this family. And to that extent, the trial judge erred in law and fact when he holds that Rita Izome is not part of the Okoye family or is not related, is not entitled to this property because she is not related. Moving on to our argument number 2. In argument number 2, we examine the trial judge's decision, which aligns with Section 3 of the Land Act. And Section 3 of the Land Act portrays or brings forth that customary land should be adjudicated using customary land, which is the law of the land. However, noting that Section 27 creates an exemption, Section 27 proceeds to tell us that to the extent where this law, which is customary, discriminates the rights of women, then it becomes unconstitutional. And by Article 2 of the Constitution of Dakala, which states that any law repugnant to the Constitution shall be null and void, we proceed to request this honorable court to strike down the decision of the trial court judge. Furthermore, paragraph 13.7 of the fact sheet proceeds to tell us that in the Tonga culture, women are not allowed to own property, which still aligns with what the trial judge held. My lordships, it is really outright and highlighted that the country of Dakala and the honorable trial court is one that speaks misogyny and patriarchy to the extent that it discriminates the rights of women and the rights of women to the extent that a one Rita Izome is not allowed to own property by virtue of the fact that, that the Tonga tribe is one that does not allow women to proceed in that manner. More to that, Article 7D of the Maputo Protocol states that equal sharing of joint property during marriage. It guarantees for equal sharing of property during marriage. And it is to that extent, my lordships, that as the appellant, we so submit that the appellant is entitled and made a significant contribution to the property in question. And therefore, one, she becomes a rightful member of the family by virtue of her contribution and to the extent of her marriage, which integrates her to the family. More to that, she is also entitled to ownership of this property in question to the fact that it is an injustice and discriminates her from her right to ownership of property and the right of equality at marriage stated in Article 31, but also contravenes Article 2 read in line with Section 27 of the Land Act. I would like to relinquish the stage to my co-counsel to submit.
Counsel, before you take leave, you cited Section 3 of the Land Act, and you made reference to adjudicating disputes arising out of customary land using customary law. And I'm looking at the section you cited, and I can't seem to find that paragraph under the subsection.
It is in...
And can you just make a brief oral highlight in regard to Section 3, subsection 1? Paragraph G.
Section most obliged.
I hope that's a revised version of the Land Act, Cap 236. You should not cite old laws.
Applying local customary regulation and management to individual and household ownership, use and occupation of, and transactions in land.
Okay, let's use a rule of harmony. Read that section in tandem with paragraph G. If you could just make brief oral highlights, because I'm under the impression that this first ground for the appellant is to demonstrate that the appellant was entitled to a recognition of that particular land as a subdivision that devolved to their household. So if you could just make a brief oral highlight in that regard.
I beg a pardon, I didn't get the question, my lord.
I'm under the impression that the crux of your argument under this particular issue is to demonstrate that the appellant is entitled to a declaration that that particular piece of land devolved to their household. If you could just make brief highlight paragraph E and G.
In which parcels of land may be recognized as subdivisions belonging to a person, a family, or a traditional institution, and which is owned in perpetuity.
And read that in tandem with section 27.
Section 27 states that any decision taken in respect of land held under customary tenure, whether in respect of land held individually or communally, shall be in accordance with the customs, traditions, and practices of the community concerned, except that a decision which denies women or children or persons with disability access to ownership, occupation, or use of land, or imposes conditions which violate Articles 33, 34, and 35 of the
Are
Constitution.
those sections relevant to your case?
Yes, they are.
Can you just make brief or highlight? Just in your words, don't recite the sections. Yes.
They speak to gender equality and the position of women. And therefore, where the trial judge's holding or decision violates the right of these women to be held equally at marriage and at the dissolution of marriage, then it becomes a discrimination of their right to ownership of property, to the extent that it discriminates them to be party to the ownership. If there's no further indulgence.
You cited the Maputo Protocol specifically, and it's kind of generic. Is there any provision that talks about customary land, protection of women's rights in that direction, apart from that regional instrument you've made reference to?
Articles 16C.
You referred to Article 7.
Yes. Article 7 speaks to equal sharing of joint property during marriage, and Article 16C speaks to the elimination of customary laws that discriminate women's right to ownership of property.
So is it binding absolutely, or there have to be other, instruments to correct the expectation there?
It is binding.
What's a dualist state?
A dualist state is one, I will explain it in this way. A dualist state is one which would be party to international laws, but would have to first ratify and domesticate the law for it to apply, for the international law to apply to its country. If there is no further indulgence, my lordships, I'd like to relinquish the stage to my co-counsel to submit.
May it please this honorable court, for the record, I am Ochuo John Isaac, and I will be proceeding with our submissions in regards to issue 2 and 3 of the matter. And issue 2 is meant to establish whether the denial to award 50% of the matrimonial property, reason being there is no production of documentary evidence in form of receipts, whether it is in violation of the right to ownership of property and of equality. Your lordships, we submit that these sacred rights are protected, specifically the right to equality at marriage, during the marriage, and at the dissolution of the marriage is protected under Article 31, Clause 1 of the 1995 Constitution of the Republic of Dakala. And secondly, the right to property is equally protected under Article 26, Clause 1 of the Constitution, which requires that no one should be deprived of their property. It is a submission that the trial court, by solely and strictly relying on evidence adduced in a way of receipts did violate the principles of equity and justice, the right to equality, and the right to ownership of property, and thereby occurs against the person of the respondent. It is a submission that, in accordance with Article 126 of the Constitution, which requires that substantive justice should be given or afforded to a person with undue regard to technicalities. And specifically quoting the words undue, which is would be interpreted to mean unnecessary regard.
You cited Article 116?
26, Your Lordship. Much obliged. As continuing, specifically the words undue require that unnecessary interference with justice will not be, should not be permitted by the Constitution. It is a submission that by strictly requiring evidence by way of receipt, there was a neglect of equity and justice. Your Lordship, in the case of Rima versus Rima, the Court of Appeal of England noted that there should be a laxity when considering rights between married couples. And specifically quoting verbatim the words of Lord Justice Roma on pages 870, he notes that cases between husband and wife are not to be governed by the same strict rules and considerations, both at law and equity, as those that applied towards strangers, total strangers. It is a submission that by denying Rita Izoma to rely on other forms of proof that are available in the facts or that are presented, especially in accordance with Section 16 of the Evidence Act, which points to the fact that admissions are concrete evidence to prove a fact and are self-incriminating to a party that uses them. Your Lordship, we submit that in paragraph 17, the respondent acknowledges that Rita Izoma has actually performed these duties. She has paid workers, she has contributed monetarily by buying food and all that. The same is not disputed. And this is evidence enough, and it is our prayer to this honorable court that other forms of evidence should not be neglected by strictly relying on only one form, which is documentary evidence in the way of receipt. Moving on, Your Lordship, it is equally our submission that by strictly relying on evidence by way of receipts, there was a neglect of the other contributions towards development of matrimonial property, as recognized in the case of Ambayo Jacqueline and, I beg your pardon, Ambayo Joseph versus Aserua Jacqueline, in which it was elaborated that contribution to matrimonial property can be direct, that is monetary, and indirect in a way of non-paid domestic care, which is defined to encompass all forms of non-paid forms of domestic work that a woman does in a family. And it is our evidence in our facts that, in paragraph 11 of the fact sheet, that Rita Izoma has contributed tirelessly to the development of the home in the production of the vanilla, which has boosted this family to the economic status they are at. It is a submission that also this should be looked and put into consideration while quantifying her contributions to amount to 50. Moving on to the second issue which I am supposed to address, and that is issue 3 to dispose of this matter, which is to the effect that, where is it? Which is, it points to the fact that whether the valuation of the appellant's non-monetary contribution at 20% rather than 50 is a violation of her right to equality and freedom from non-discrimination. It is a submission that by only evaluating it at 20%, there was a violation of this right to equality. Your Lordships, it is evident that factors that are considered in order to reach to a proper quantification, as noted in the case of I beg your pardon on that. Is it? I beg your pardon. In the case of Rabinumi versus Bahimbi Somwe, Supreme Court Civil Appeal number 16 of 2009, where it was noted that factors such as the length of the marriage should be looked into, factors such as the life expectancy of a spouse, factors such as the number of children that have been given birth to during the subsistence of the marriage. These factors have been neglected by the trial court while awarding her the 20%. It is a humble prayer and submission that had the trial court put into consideration these other factors, there should have been a raise from 20% to probably even the 50% that is required. But the neglect of the same has caused a detriment to the appellant. It is equally a submission that the Honorable Trial Court did not attach specific values to whatsoever non-paid domestic care work that it quantified so as to amount to a 20%. It is a submission that the case of Rabinumi versus Bahimbi Somwe requires that while considering non-monetary contribution, the court can look at what is the market value of each and every contribution that a person or a spouse has made in the marriage. And by not attaching what specific values are attached to each of these, there has been an injustice occasioned to the person of Rita Izoma. And it is our prayer to this honorable court to look into these factors that we have propounded in order to raise this, the value of the contribution of Miss Rita Izoma from the 20% that she was awarded for her work that has been done for 16 solid years each and every day, to increase it to the 50% that she sought. If I'm not of any further indulgence, I beg to allow my colleague to submit.
Council, just to seek clarification, you talked about the fact that she contributed to giving birth to children, 4 of them. How would you quantify that in monetary terms?
Contribution by way of production of children is not actually, cannot be quantified. Reason being that the children, you cannot attach price to human beings. But the aftermaths of childbirth, which are the fact that she needs to probably seek for a leave from work, thereby reducing her earnings, this all contribute towards the fact that she is cutting part of her time, which should have been used for economic earning, and then diverting it to child rearing, for lack of a better word, child rearing, and all the other things that come along with having children. And it is a submission that there was a miscarriage occasioned towards the appellant. I would welcome my colleague to make her submissions.
May it please this honorable court, for record purposes, I'm Councillor Nakale Hajara, and I'll be handling issue 4 and the prayers to this honorable court. Proceeding to issue 4, which provides that whether the appellant is entitled to the relief sought. Your Lordships, the appellants seek relief of a 50% share of the matrimonial property where the marriage was situated on for a period of 16 years. Your Lordships, we seek relief to this honorable court for an increment of the valuation of unpaid work from 20% to a 50% be granted to our appellant. Your Lordships, the appeal of Rita Izoma against the decision of the High Court of Konde District raises critical questions about gender equality, non-discrimination, and more so the right to property. and we therefore aver that the appellant is entitled to the relief sought. Your Lordships, to support our submission, we shall rely on the constitutional and statutory framework of the Republic of Dakala. Article 26, Article 31, and Article 33 of the Republic of Dakala really provide a strong foundation for the appellant's claim, since it provides for the equality, including the right to property, which my co-counsel have properly submitted on. Your Lordships, furthermore, considering the international human rights instruments ratified by the Republic of Dakala, that is Article 16C of the Convention on the Elimination of All Forms of Discrimination Against Women, Article 7 and Article 8 of the Protocol to the African Charter on Human and People's Rights on the Rights of Women in Africa, also commonly known as Maputo Protocol. Your Lordships, all these instruments really obligates the state to ensure that there is equitable sharing of the matrimonial property when it comes to issue of its dissolution. Your Lordships, it is further reinforced in the landmark case of Mifumi Uganda Limited and another versus Anton General of Uganda Supreme Court case 15 of the year 2015, where the Constitutional Court of Uganda held that customary law provisions discriminating against women's property rights were unconstitutional. Your Lordships, in specific to the fact sheet, paragraph 13 and paragraph 17 really contains that the Tonga tribe, that's the customary laws, really denies the Tonga tribe women the right to property. Your Lordships, in addition to this, in the case of Ambayo Joseph versus Aselua Jacqueline Civil Appeal Case number 1 of 2015, the High Court of Uganda ruled that a wife's non-monetary contributions to the marriage, including child care and house chores, entitled her to a share of the matrimonial property. Your Lordships, our appellant, Rita Izoma's non-monetary contributions towards the development of the property in suit should not be undeniable. Your Lordships, it is evidenced in paragraph 11 of the fact sheet that our appellant used to graze the animals, used to take the children to and from the school. She used to wash the clothes for the respondent. She used to cook not only for her household, but also for the workers at the farm. Your Lordships, the High Court is granting of only 20% of her unpaid work really undervalues her contribution. Your Lordships, she did all this unpaid work for a period of 16 years. My Lordships, it's 16 years, not that. Your Lordships, based on that, I would like to proceed on our prayers to this honorable court. It is, Your Lordships, it is therefore our prayer to this honorable court that be guided by the case of Fazana Sensio Begumisa and 3 others versus Eric Chibivanga Supreme Court case number 17 of 2002 as the first appellant court to reappraise the evidence and the matters raised to this honorable court to grant its decision for our matters. Your Lordships, it is on this basis that we pray to this honorable court that finds the appellant entitled to the relief sought. Furthermore, Your Lordships, it is our prayer to this honorable court that it partially overturn the trial court's judgment, recognizing Rita's equal rights to property and upholding the principles of gender equality, since it really erred in law as my co-counsel submitted earlier. Your Lordships, it is our prayer that this honorable court increases the valuation of the sweats, the sacrifices that were done by our appellant in form of unpaid work contributed to the appellant for a period of 16 days, Your Worship, it's our prayer that it is increased from 20% to 50%.
Council, are you saying 16 days? Are you amending your facts?
Much obliged. Council, I meant 16 years. Your Lordships, it is our prayer that this Honorable Court makes a pronouncement of itself to ensure that men and women are born equal. They have equal rights to property, and they have equal rights that's at entering, during, and at the dissolution of this Honorable Court.
Are you dissolving the court?
Of this marriage, it's our prayer to this Honorable Court that considers our prayers, and we so submit.
There's a Supreme Court decision that you cited. Can we go back to, is it 17 something? I just want to, how did you cite it?
It is, in much obliged, Your Lordship, it's Father Nasensio Begumisa and 3 others versus Eric Chibebanga, Supreme Court case number 17 of 2002.
A civil appeal or criminal appeal? Let's have the proper citation.
Much obliged, Your Lordship, it is a civil appeal.
Supreme Court civil appeal number?
17 of 2002.
Now that's a proper citation.
Much obliged.
Yes. Before we take leave of your team, now this is a question to the 3 of you. I don't want to wait until the end to give comments. So I just want to find out. I noticed that you did not cite the the objective principles. Let's go to objective principle 25. Okay. Okay, hold up. 25, 24, paragraph A, and article 8A. And those objective principles relevant to your case?
Much obliged, Your Lordship.
You don't have to do highlights. I just wanted to bring that to your attention.
The principles are very much required on our case.
It's okay.
Respondents?
Much obliged. Much obliged, Your Lordship. Your Lordships, for purposes of this court's record, my name is Katsime Elizabeth, lead counsel for the respondent. My Lordships, we were allocated 30 minutes of this court's time, and we intend to use it in this way. I, the lead counsel, will use 10 minutes to submit on merits entailing issue 1, to respond on issue 1. My co-counsel will use 8 minutes to respond on issue 2, and the last counsel will submit on issue 3, 4, and giving prayers to this honorable court using 12 minutes. Your Lordship, as the respondents, I am going to appear jointly with co-counsel Changu Banda, co-counsel Joel Musiba. Your Lordships, as the respondents, we do not dispute the fact regarding to the jurisdiction of this honorable court as submitted on by the appellant. Your Lordship, still we do not contend with the facts, as we do not want to waste this court's time. Your Lordship, the appellants came up with grounds of appeal, which stated, the first being stating that the land trial judge erred in law and when he held that the appellant was not entitled to any share of the property on which her and the respondent's matrimonial home was situated. Second being, the land trial judge erred in law and fact when he held that the appellant was not entitled to 20% of the value of the property on which her and the respondent's matrimonial home was situated. Your Lordships, from these grounds is where we get the issues 1 to 4, which we are here to respond to. Your Lordships, if I may respond to the first issue, the appellant cited the case of Rabinumi versus Bahimbisomwe, Supreme Court Civil Appeal number 10 of 2009. And I would like to emphasize that the same case, Your Lordships, the land, your sisters and brothers, land trial justices, disregarded the claim of church marriage and vows entitling each spouse to equal distribution, as the appellant submitted that the two people became one at their marriage. Your Lordship, if I may invite this honorable court to be persuaded by this same case, where your trial land justices emphasized that and disregarded the claim of church marriage entitling partners or spouses to equal distribution of property at the dissolution of marriage. Your Lordships, if I may submit further in response to the appellant's submission, it should be noted that as they stated that the appellant was part of the Okoye family. Your Lordship, at this point, their marriage is dissolved, and she is no longer a member of the Okoye family. And if we are to say that she is still a member of the Okoye family, if we look at the fact that if she leaves this home, she will no longer be a member of the Okoye family, and if a share of the property on which the matrimonial home is situated is given to her, this will lead to this will stop or it will bring to the end of existence of ownership of customary land by the Okoye family, because it has been divided and given to her, and she is no longer a member of the Okoye family. And in this, she holds the land solely. Your Lordship?
Counsel, is it your submission that individuals cannot have own subdivisions in customary tenure?
They can, Your Lordship.
Can you please go to section 3 of the Land Act on the
Your Lordship, if I may state it verbatively.
Just make a brief highlight.
Okay. It states that customary land can be subject to subdivisions owned individually or as an institution.
And from the facts of this case,
yes,
the proceeds from the sale of the produce cultivated on the land
yes,
was divided between the appellant and the respondent. Is that?
I beg to be pardoned.
The proceeds from the crops that were cultivated on the land,
yes,
those proceeds were shared between the appellant and the respondent, 80 and 20%. Is that true?
Yes, my lord.
The 80% that was taken by the respondent, was that held in trust for the clan?
My lordship, if I may answer that question, the 80% was taken by the respondent to look after or to make developments on the same suit piece of land, your lordship. And from these developments, because they were subjected to land use. as customary land can be subjected to land use, your lordships. In this case, they were using the land to develop it in favor of the Okoye clan, your lordships.
Okay. Just before you take leave, you submitted rightly that the appellant taking part of the land would then disadvantage the Okoye's family. But also from facts that are before you is that the parties just after their marriage worked together, tilted land, grew vanilla, and constructed a 5-bedroom house.
Yes, your lordship.
Would that qualify as a matrimonial property in that regard?
I request to be pardoned on that matter.
Would the property constructed, the housing where the family derive their living, be qualified as a matrimonial property in this case?
Your lordship, if I may quote the Latin maxim, you will pardon me, I'm going to read it due to the pronunciation problems. The Latin maxim, quid plantata sedit.
Yes.
Your lordships, what is put on land becomes part of the land. And the fact being that this is ancestral land and it is not subject to division, the trial court's decision, they based on the contribution on based on the developments, let's say the yields that they used to get from the vanilla plantation, but did not touch on the property on which their matrimonial home was situated, the home inclusive, and that is why we are here to resolve such an issue, your lordships.
So in simple terms, you're saying the home did not form part of matrimonial property because it is situated on a customary land?
Because it is a fixture, your lordship, it cannot be moved.
Proceed.
Much obliged, your lordships. We as the respondents, we recognize the repugnant customary norms, and that is why we are here. We do not dispute the contribution of the appellant, and in this, we argue, we also support the theme, and that is why we are here. We are here in the need for family reforms, your lordship. The trial court's decision to grant her 20% was from the valuation of her contributions, and the land is not part of the matrimonial property. Your lordship, if I may refer this honorable court to be persuaded by the same case of Julius Rabinumi versus Hope Bahimbi Somwe, Supreme Court Appeal number 10 of 2011, your land trial sister, Justice Esther Chisache, stated or observed that customary or matrimonial property is understood differently by different people. And there is that property that a spouse can own privately before, during, and after the marriage. And there is that property to which the husband can hold in trust of the clan. And there is also that property that the spouse or the couple choose to call home. Your lordships, in this instance, the husband was holding the property in trust of the clan. However much I stated that that customary land is subject to your lordship, I am requesting to be granted 1 minute to give us a session on my issue. Much obliged. However much this customary land is subject to divisions, subdivisions, and owned individually, it is still part of the ancestral land, and this land is there to bring about continuity in the family. It is an ancestral piece of land. If it is divided, how, let me give an example. Where will the grandchildren of this couple come back to if this piece of land is changed from customary
Council,
to
you're
individual
engaging
ownership?
in speculation. Court does not convene for academic purposes. Let's stick to the facts on record.
Okay, much
I want to refer you to paragraph 9, the third, from the fourth line downward. Because you seem to cite the case and the decision of the judge in context of the fact that she is saying properties acquired before marriage would not constitute part of matrimonial property. But I want you to look at your facts, paragraph 9, the second from the fourth last line.
Okay.
Would that facts be distinguishable from the case cited?
I beg to be pardoned, Your Lordship.
In simple terms, by the time they moved into this property,
Yes.
were they married?
They moved to it after they got married.
And looking at those facts you've just confirmed with the case cited, would that case be applicable to your case? The dictum of Justice Kisachi.
Regarding property owned after marriage, in that line, Your Lordship. Okay, much obliged, Your Lordship. This land was there and it still belonged to the Okoye clan even before the two couples were married, Your Lordship. As I conclude, I would like to persuade this honorable court with the case of Mutefu versus Mutefu, civil appeal number 214 of 2000.
Just go on the principle. You're on borrowed times already.
Oh,
yes.
Much obliged. We pray, as the respondents, we pray that the trial court's decision be upheld, Your Lordship. And if there is no further indulgence, I would like to yield the floor to my co-counsel to submit on issue 2. Much obliged.
Much obliged, my lords. For purposes of court's record, my name is Changu Banda. As earlier stated by our lead counsel, I will be using 8 minutes of this court's time in response to the appellant's second issue, which is whether the denial to award the appellant 50% of the property on which her and the respondent's matrimonial home was situated on the basis of equality and discrimination. My lords, going further, I would like to put it before this honorable court that it is our stand as the respondents that the trial court's decision not to grant the appellant 50%, basing on the fact that she did not produce documentary evidence, does not contravene with any legal provisions in the Republic of Dakala, bearing in mind that court is a court of record and not allegations, my lord. Going further, the appellant stated Article 31 of the Constitution stating equality at marriage, during marriage, and at its dissolution. My lords, they also stated Article 26 bringing in the principle of fairness. But I would like to pose this to them back again, saying fairness does not mean an equal division without evidence of contribution. My lords, I pray to persuade this honorable court with the case of Ambayo Joseph Wago versus Aseroa Jacqueline, civil appeal case number 100 of 2015, where courts recognized both the direct and indirect contributions, my lord. However, it stated that the non-monetary contributions should be given a monetary value. When it comes to the issues of receipts, my lord, it clearly stated that the direct contributions made by the wife, rather, or both parties, should not be entirely disregarded when it comes to the division of matrimonial property. Going further, my lords, the appellant stated that this was a necessary interruption of justice, claiming that the trial court, wanting receipts, was a necessary interruption of justice. Bringing it before this honorable court once again that courts is a court of evidence. My lords, under paragraph 9 of the facts at hand, it is stated that both these people moved on this property. However, this person did not produce evidence. And if we're looking at contributions in the form of receipts, I refer to the property rights of the Okoye family. Since we're looking at the principle of fairness, my lords, will the appellants grant fairness only to one person, neglecting the other property rights of the Okoye family? Is that what fairness means to the appellants? So, my lords, it is our submission as the respondents that yes, we do not dispute the fact that Rita Ezoma worked on this property as evidenced under paragraph 11 of the facts, but we argue that these contributions merit a 50% share of the property, my lords. Going further, the appellants brought in Section 16 of the Evidence Act. However, it is our humble submission as the respondents in response to this, bringing in Section 101 of the Evidence Act, stating that he who alleges must prove. And my lords, bearing in mind the position of the law, that this is based on the balance of probability. Going further, my lords, just as the appellant stated that other forms of evidence should not be neglected, and we truly agree with them. In reference to the case of Ambayo Joseph Wago versus Aserewa Jacqueline, that the appellants themselves mentioned, they left out the principle that stated that direct contributions should not be entirely disregarded when it comes to the contributions and rather divisions of this matrimonial property. My lords, furthermore, I pray that this honorable court be persuaded by the case of, by the case of Peace. I'm sorry, my lord, the pronunciation of that surname. It's called Peace Uhiriwe versus Kuku Kagwapa. In this case, my lords, this woman was granted only curtains because that was the only thing she was able to prove. She managed to prove that throughout their marriage, the only thing that she had contributed were curtains, and that's what court granted her in this case. My lords, furthermore, we pray that this honorable court...
Counsel, give us a full citation of that case.
Uhiriwe Peace versus Kuku Kagwapa and Diana Natu... My lord, sorry, pronounce it. Can I spell it out? Natuleved. And, sorry, divorce case number 118 of 2017. Going further, my lord.
You're citing a High Court decision to bind this Court of Appeal?
No, much obliged, my lord. We pray that it is persuasive to this honorable court. Going further, we as the respondents acknowledge the appellant's contributions towards the matrimonial property, but we argue that these merit a 50% split. Therefore, my lords, it is our prayer that this honorable court upholds the decision of the trial court and that the claim of the 50% split of matrimonial property should not be granted. We so submit, my lord. I pray to you to flow to my co-counsel to submit on the last two issues.
May it please this honorable court, once again for purposes of court's record, my name is Joel Msiba, counsel for the respondents. My lords, I will be responding on issue 3, issue 4, and as well give prayers for the respondents. My lords, before I even submit and respond on these issues, I would like to submit that the decision of the High Court was based on the laws governing Dakala, principles of equity, and legal precedents within within Dakala, my lords. My lords, I will be responding now on issue 3, which states that whether the trial court's evaluation of appellant's non-monetary contribution in the form of unpaid care work at 20% rather than 50% was of the property on which the respondent's home was situated was in contravention of legal provisions relating to the right to freedom from discrimination, as well as the right to equality at marriage, during marriage, and at its dissolution in the Judicature Act and the Constitution of the Republic of Dakala. My lords, submitting on this issue, I will be basing on two limbs of arguments. One, that the land trial judge warned himself on the rights of other Okoye members before granting the percentage to both Rita and Robert. Two, that the court looked at the equality after marriage. What would be the burden of each spouse after marriage? My lords, before I advance in my submission, I would like to put into this court's attention that the property under which we are contending on was splatted on Okoye land, which is a customary type of land. My lords, it could be unfair to value contributions of each spouse without recognizing the rights and interests of other Okoye members. My lords, I'll persuade this honorable court by the Latin maxim, quid plantata solo sedit, which is to the effect that whatever is placed on the land becomes part of the land. My lords, there are two issues. There is a fixture and a chattel. However, they look at a degree of annexation. The land, the house was put on this land in annexation that it is going to be used for permanent land. It cannot be removed. And when it is removed, it causes damage on the land, my lords. My lords, furthermore, I will persuade this honorable court with the case of Muanga versus Chintu. I Court divorce case number 135 of 1995, 97, whereby the land trial judge, the land judge, that is just Judge Bosa, looked at the property in three aspects. One which a spouse owns as an individual. Two, the one which a spouse owns as owns in association with interest of the clan. And three, the one which the spouse and respondent or the spouses call home. My lords, much as this property is referred to as home, however, this property is owned by the respondent in trust of the clan. My lords, it cannot be further divided without consultation and without putting in consideration all the interests of other Okoye members. And as such, my lords, it's our submission that the land trial judge used equity to provide a remedy to both Robert and Rita, who doesn't own this land electrically because it is owned by the Okoye clan, to find a way that they can get a portion because they had both helped in the development of this land, because he looked at the indirect contribution of Rita, who was cooking for the family, carrying out agriculture, watching children, washing clothes of the children and respondent. However, he went also ahead and looked at Robert's contribution, which was in form of finances, that was the elect, whereby he buy tools, buy seeds, which were planted in the vanilla plantations, and even gave in other expenses like paying for the workers. And my lords, I would persuade this honorable court with the case of Ambayo Joseph versus Anserua, Jacqueline Civil Appeal Case number 100 of 2015, whereby the court put up a principle that when we are determining contribution of each spouse, we cannot disregard the spouse's monetary contribution. My lords, furthermore, the appellants relied on Article 31, stating that it grants right to equality within marriage, at marriage and dissolution. However, your land sister Esther Kisache, in the case of Rabinumi versus Imsowe, civil appeal case number 10 of 2009, it stated that this article was put up to back up Article 21, whereby they look at rights of individual within marriage, and these rights are equal, whereby they have to equally contribute to the development of the home. And as such, each spouse is given according to his contribution or her contribution. My lord, it's our submission that when the land trial judge looked at the interests and the rights of the Okoye members and equally looked at the contribution of each spouse, came out to a conclusion that the appellant was expected to get 20% and respondent to get the other portion. My lord, in this instance, Rita is even on a safer side because Okoye family can say that let Robert go because it's now
Council-
Robert who has remained on the
Council,
land.
Stick to the facts on record. Stop submitting from the bar.
My Lord, paragraph 9 clearly states that these people settled on Okoye land. That's why I've been submitting in this same lane. My Lords, the appellants used the case of Mifumi Uganda Limited versus Anthony General, whereby they stated that rights of women over property has been over time deteriorated. However, we have to put in consideration what is the matter at hand, what is the facts within the case before determining the case. My Lords, in this case here, we are looking at a situation whereby the land doesn't belong to the two. It belongs to Okoye family. And the court is finding a way of justly and under equity giving a portion to each person and putting in consideration the rights of other people. My Lords, I'll submit on my second limb of argument when responding on the appellant submission that the court warned itself on equity after dissolution of marriage, whereby court granted the divorce, it granted joint custody. However, it gave full maintenance to only Robert under Section 76 of Section 76 of the Children's Act. That is Cap 59. Cap 59. Maintenance of children include paying them school fees, giving them.
Is Cap 59 still relevant as of now to cite the children's statute?
I stand to be guided, my lords, on the new cap. It's our Cap 62. My lords, maintenance includes giving basic needs to the children. This was left to only Robert. So when court was looking and putting in consideration of this equity after, it looked at this, because if you grant 50% to the appellant and grant 50% to the respondent, yet the burden, the higher burden is now lying on the respondent to be paying all these. It is, my lords, it would be unjust. So it's our submission that court relied on the principles of equity to give this 20% to Rita and the rest to be given to Robert. My lords, I will now submit on my last issue, which states that whether the appellant is entitled to the relief sought. My lord, submitting on the same, the appellants relied on the case of Rabinomi versus Opwa Imbisimwe, civil appeal case number 10 of 2009. However, they were looking at the aspect that they granted the 50% to the appellant of that, to the appellant in that case, forgetting it that the land trial judge also stated that they look at the contribution of each spouse. Now here, the contribution of each spouse was clear, and the land justice and the land judge at the trial court considered it under paragraph 19 in form of unpaid care work, and as such, reached at a conclusion that indeed this appellant was only entitled to 20%. My lords, furthermore, the court also looked at the contribution in the form of monetary term to the respondent is said, that is, I pray that this court is persuaded by the case of Ambayo Joseph versus Ansarua Jacqueline, civil appeal case number 100 of 2015, where court also went ahead and said that it cannot disregard monetary contribution when it comes to division of matrimonial property. My lords, now I'll give prayers for the respondents. By the powers granted to this honorable court pursuant to Articles 134, Section 66 of the Civil Procedure Act, Cap 282, Section 10 and 11 of the Judicature Act, Cap 13, section read together with Section 32 of the Court of Appeal rules, whereby this court has powers to vary from the decisions of the High Court or to confirm the decisions of the High Court. We pray that this court confirms that indeed the decision which was carried out at the High Court was based on equity, based on legal precedents of this country, and based on the laws governing Dakala. We so submit counsel for the respondents.
May it please this honorable court, we reserved 3 minutes for our rebuttal, and I will be delving into that. We submit that we did not quote Article 26 and are not about to quote it as referring to the right to equality, but rather the right to ownership of property. Secondly, Your Lordship, it is a submission that the notion that the appellant, by the fact of divorce, should be regarded as rubbish discarded from family and not entitled to anything is misogynistic and patriarchal in nature. This honorable court should distance itself from the same, and our country, Dakala, cannot be seen perpetrating such a thing. Marriage brings lifetime effects. Children, how would they explain to the children that your mother is a discard? It's an absurdity. It is equally a submission that, Your Lordship, we did not specifically pray that this court should disregard in totality the evidence of receipt and thereby neglecting any form of evidence to prove or to substantiate any ownership of the property. But rather, we submitted that there is alternative evidence that could be looked at, thereby making the requirement of receipt unnecessary or undue in the words of Article 126. It was equally a submission that the Honorable Court should take into cognizance of the evidence.
Counsel, please. Why are you quick to cite Article 126 on technicality, and you don't mention any sections from the Evidence Act?
Much obliged. Your Lordship was moving to that, and it was equally a submission that Section 16 of the Evidence Act requires that an admission when made is evidence towards the same and is self-incriminating to a party that makes the same. And that is our submission, that there is alternative evidence that could be looked at by this honorable court in replacement of the requirement of receipt, since the marriage has been subsisting for 16 years, and also considering that the biggest sector is informal in nature, and women contribute 10% more labor in the informal sector than the men. We do not expect a very formal requirement, such as receipts, from an informal sector. Your Lordship, there is a miscarriage of justice that was perpetrated in that area. It was equally a submission that other forms of evidence be looked at just for that. And Your Lordship, in wrapping up, I will equally quote the Latin maxim, quid plantatur solo solo sedit, which was cited earlier, that everything that is affixed on the land does belong to the same. Just to wrap up, it is a submission that we did not strictly pray for ownership, but also, if this court finds that we cannot have ownership of the property, they could award a commensurate value of the property towards the respondent, thereby not depriving the other family members of the land, but also not totally depriving Rita Izoma of her 16 years worth of contribution towards the same. We beg to submit there.
Maybe before you take leave, do you have a copy of the Evidence Act, the revised Evidence Act?
Your Lordship, unfortunately, I do not.
Okay. Hopefully next time you refer to Section 64, subsection 1C.
Much obliged.
Okay. But also, just in addition to that, consider Section 59 to buttress your argument for the need that receipt is not required, most especially where facts have been admitted to that extent. that somebody contributed work, and therefore no further proof would be required under the rules.
Much obliged, Your Lordship.
There are quite many international judgments that have been made in terms of care work, which you need to embrace and appreciate the fact that we have international laws, regional laws, and national laws. And so we need to appreciate the context within which Dakar operates and how culture treats women customarily. Thank you.
Court is adjourned. We all rise. As the norm, let the applicants and respondents shake hands as the judges take their leave for a short break.
Excuse me, ladies and gentlemen, we are going to be going for lunch. They're still setting up. They need about 2 to 3 minutes to finish, and then we will, in an organized manner, walk to the tent where we had break tea. We are going to request that we use 45 minutes. The judges for the final round are already here and already having lunch, and as soon as they are good to go, I'll request that we come into the room. So let's kindly take note of that time. Thank you.
One gentleman calling me, and guess what? I mean, this is a teenager on phone, and this gentleman was naked. Yeah. My name is now Karatenjo Teddy. I'm a journalist by profession. And about online gender-based violence, I am a victim, and I've seen so many women who are victims as well. Online gender-based violence really had more impact on my life. It's when I started, you know, okay, you've put aside what really happened. And I remember posting a picture sometime. I used to be a tiny girl. I was young anyway. And someone called me how I was too skinny, that I looked sick. And to me, it just got me thinking, okay, you don't even know me. You don't know even why I'm skinny or something. And then seeing myself have some weight, sometimes I look back, because that's a comment that never leaves my head. Someone came out and told me I was skinny. I looked sick. Body shaming has happened to me. Stalking has happened to me. The harassment in general, to a point that I can post a picture and just remove the comment section, because I really don't want to see what people have to say. Someone will just come and you're wearing shades and they will abuse you. You know, someone thinks they should dictate how you dress up. I have seen it all on social media, that nowadays I just decide to have peace of mind. Sometimes I just turn off the comment section. To be honest, the only support I got was to share with someone. And it so happens that when I shared with someone, they were saying it has happened to them all the time as well. So the advice they had was like, Never mind such negativity, just move on. But that's quite hard, not to mind the negativity. So even up to now, I'm still trying to fight that it's okay, Tenjo, be confident, post and not remove the comments. So that's how I also joined in the fight to this, because no conversations have been created about online gender-based violence, yet it is happening at its peak. So to be honest, even up to now, I'm still figuring out how do we help people that have been in a situation like me. Even reporting is kind of slow to me. It feels like it's very slow. Because I remember one time, my sister's account was hacked and we kept on reporting up to date. They have never blocked the account, it's still there. Someone is using it to do anything they want to do. Why is it that we don't have an online police that can detect all that? These platforms have all the money that they can do to have someone that can translate what happens in different languages. But then do I have to report? Can't you see, the same way you can put a song and they say, because this song has copyright, it can't go to certain countries. Why don't they do the same? Like, I mean, for them to monitor no matter the language someone uses, because people be vulgar on social media. And you can't tell me because it's not in English, you won't help, that I have to report. Because I may be harassed and I decide even not to report, and I just decide to step down minus reporting. But this won't stop. It will happen to another person, another person. I believe the fact that conversations are going to be started about online gender-based violence, people are going to address it because it's happening, but people are quiet about it. It's like the new normal. But when we start conversations where we are going to create awareness to people, where we are going to tell people that it's not okay to body shame someone, it's not okay to do this, people will learn, because why would someone be savage with someone they don't know? So by starting up conversations, we are going to address this matter, because through those conversations, we are going to advocate and inform people that what you're doing is not right. You can be a little kind than being, savage. Dear community, how about we spread some little love, just a little love. All in all I would request is let's all work together to end online gender-based violence.
As respondents. And then Team A, as the first runner-up, had Team G, as the first runner-up, had 69.6 as appellants and 57.4 as respondents. That makes Team G versus Team A. Team G as the appellants and Team A as the respondents. So we have 15 minutes for the justices to be coming in. The teams could pick a copy of the results.
Ladies and gentlemen, I'd like to call us to order so that we begin our afternoon session. As we celebrate the wins that are moving to the next step. Good afternoon, ladies and gentlemen. Let's settle. I'd like to have the teams that were competing on the first and second lane for ease of movement when the proceedings begin. I'd like to recognize the presence of our partner who is making it possible for us to have this Moot IDLO, who is present in the room right now. I do not hear a hand clap. I do not know where our water would have come from today if IDLO didn't do that for us. Thank you so much, IDLO, for making it here. We do not take for granted the fact that you come for events like this. Ladies and gentlemen, allow us use the next few minutes before the last session of the day to get feedback. One of the major purposes of such moots is to help students improve, is to build capacity, is to support you in your further, engagements as you do this work. Would like to use the next few minutes to have our judges from the morning sessions give us feedback to the different teams that participated, and then we will start the last session of the day. There is a bit of noise at the back. Are we okay? Have we settled? All right. I think we've settled. There is still a mini meeting here. Susan and Tim, are we okay? I'd like to invite our judges from the morning session to please come up to give their comments, or would you prefer to give your comments from where you're seated?
The students ask. Oh my God. sorry. A lot. Good afternoon, ladies and gentlemen. Congratulations to the two teams that advanced to the finals, and congratulations to the students who participated in this exercise. Now, my comments are just brief observations I made. And the first observation is that I noticed the students are very quick to cite case law, and then they ignore the statutes. Don't forget your lessons from your first year regarding hierarchy of laws. That's very important, and that's a skill that you should demonstrate in your continuing education as students, and that's a skill that you should also transfer to your practice. Because in practice, we pay we pay a lot of attention to such things, because basic case law interprets the statutes. So if you start off by citing case law without taking me to the statutes, that creates the impression that the wording of the national objectives is so generous that litigants use that as a point of entry to build on international conventions. But when you go straight to the body of the Constitution and ignore the national objectives, it becomes very difficult to integrate the international conventions into the domestic perspective. So for the teams that advance to the final phase, please pay attention to that when you're appearing before the real judges, because that will impress the real judges. Then also when you're citing your cases, for purposes of this moot, we ignore the procedure aspects because it's a mixed group. We have students from first year all through to fourth year. So you've not covered substantively procedural law, but at least with a substantive law, there is no excuse for that. So those are some of the things that you should pay attention to. So if you're citing an authority from the Supreme Court and you're still telling me the trial judge at the Supreme Court, and I'm thinking, are you citing an presidential election petition and it's appellate litigation? So just pay attention to some of those things, and that's the same skill you should transfer to your work. Thank you.
Thank you very much, Benon. Good afternoon, ladies and gentlemen. I would like to give my general comments and observation from the sessions that I was very privileged to be a judge. I would start by fleshing out the idea that there has been a conflation, at least with some of the teams that I managed to judge, between constitutional petitions and this being an appeal. So the distinction should be very, very clear. Because whereas the Court of Appeal can at the same time sit as a constitutional court, the mandates are different. And the arguments, the way they are phrased, are also different. Secondly, I did observe a lack of significant threshing of ideas. Say, for instance, if one is arguing cultural practices, you need to begin with the parties to the case, okay? It is Rita before the court, but then you're saying this represents other women. So you should be very careful in trying to have generalized views or something like that when making submissions before the court. The other has been a general reference to international law, which is, of course, very much appreciated. But also there is need to understand that as the state being a dualist state, those international conventions you cite must be domesticated by the state for them to have force of law within the country, the state of Dakala, that you're citing them in your pleadings. And lastly, I want to congratulate every of the teams that have participated and wish good luck to the teams that have proceeded to the final round. Thank you. You're very much progressing and we're very proud of you.
Thank you. I have been out, so I'm not sure the comments that Benon gave. So in case I make a repeat, it will be for emphasis. But looking at the team that participated this morning, I think on a threshold of competence, they knew what they were doing, and that was very commendable from my side. It was evidence of hard work, enough research into the required assignment, as demonstrated in the write-up, but also their quick knowledge of the facts, the relevant laws. My only challenge was that there was lack of quick connection of the facts to the law quickly, like he cited. We are all so much into the authorities. We are not bringing the facts first and then placing the legal statutes and then the decided authorities of cases. And also, there was a bit of lack of confidence from a few of the participants, most especially when questions are put forward, then they get off track instead of staying on track or back on track. That is not connected to anybody, it's just my statement. It is important that you do not manufacture your own facts. And that was very visible among almost all the participants, that they would import their own facts to explain the analogy they want to put forward. And that you're setting out your own case, you'll argue your own case, resolve it, and do it in the way you want, but not the way required. But by and large, for me, I think it was a good session for all of us, and congratulations to the team that made it to the finals. Also, congratulations to the team that made it to come to this day. We were made aware that it was competitive between many universities, and then the best four made it to Makerere. And therefore, we thank you for making sure that you made it, that we are also here to be part of the process. Thank you.
Thank you so much. From my end, I think I appreciate the teams. They were eloquent. Their voices were very clear, which is good for all of them, okay? But also there was somewhere I would see that the teamwork is lacking, where someone didn't know the exact statute. So they needed support from the team. They would come in very fast. Some would do it, some wouldn't. So it's very important to cite the correct law in full, but also updated law so that you don't quote obsolete law. At the moment, there's quite a lot of reform, and so we need to take cognizance of that, but also appreciating the fact that there are very progressive legal frameworks that are trying to transform the adjudication on matters of customary land matters, among others. So we need to read widely to cross to other countries and appreciate the legal reforms that are happening. But also, I didn't see people bring out the issue of care work very well. Yeah? This work needs to be quantified. So we need to appreciate the fact that the work happens, and home is a space where women, majority of the women, invest their time and work. So you need to know the commensuration of that work on a particular, like if someone is taking care of the child, if someone is washing your clothes, how much does it cost? And so that realistic articulation needs to come through from a very practical point of view. My last one is around time. So we need to manage time. If you're given 30 minutes, please don't exceed, because the judge will get bored. And they will not even write what you're saying. And so it's very important that you are alert with your time and you use it very well. So thank you so much for everyone that has participated. I think it's worthy an experience for us to take cognizance of, but also to network with the different universities. I think this is very powerful, and it should continue. Thank you. Please clap for yourselves. You know it's healthy to clap, but also to smile to your neighbor. Do you know the neighbor, or you're seated in universities-like setting? Vendish is somewhere there, I can see. Then Mookish, yeah? So you need to get a new friend from here. That's when you'll get presidents from Gulu University. Where are the people from Gulu? Gulu is this side, okay. Gulu needs to move somewhere. Then Makerere. Still in the same space. So you need to continue networking. In that way, you get better precedents and new knowledge on what's happening in this sector. So in real practice, you don't need to be in one space. You need to get information, up-to-date information, to convince the judge that what you're saying is the best, to the extent that you can even request for allocation to that tune of 80%, depending on your argument and the information you bring forward. So it's very important that you continue getting more information on the same. Thank you so much. Where is Kemi? Let me hand over to the right person.
And then I will hand over to the clerk of this next court to invite in the judges. Make haste. Your Team A, I can't see you at your side of the table. All right.
Good afternoon, my lords. Can we start with some introductions? In the Supreme Court of Dakala at Kiante, Civil Appeal number 0274 of 2024, Rita Izoma, appellant versus Robert Okoye, respondent.
Good afternoon, sorry. I don't think it's evening yet. Yes, we are very glad to be here in this, the final round of the second National Inter-University Gender and Human Rights Law Moot Court competition. We are actually judges, we are not actors. So, as you know, in a moot, we try as much as possible to design or to play it out as you'd find it in a court. And that is why real-life judges are invited to try and hear you resolve what could possibly be a real-life case in any court of law. Yes, I will begin, yes, with introductions, as she requested. My name is Eva Luswata Kauma, Justice of Court of Appeal. I left Makerere University 1990, so some of you are not probably born. I was very excited when I got here, and wow, I see this big white building looking very American. But we used to do our law in the little room that you see going down our third year law class of 11 girls and 40 boys was just there. So we've been where you have been, and we are very excited to be meeting you. I'll allow my colleagues to introduce themselves, beginning with the lady on my left.
Thank you, Lead Justice. My name is Elizabeth Jane Alivisa. I am also a judge of the High Court, and I work in the Land Division. I finished Makerere in 1988. To be honest, when I was coming here, I got lost. I found myself going, and I said, this is CCCE. I said, oh, I remembered it was down there, things had turned.
Then when I reached the white building, I said, now I'm really lost. But then I saw our old building, and then I felt, I'm happy to be here and be part of this Moot. Thank you. I'll go next to the next senior judge, Justice Batima.
Get it wrong. Justice Batemandi Kavona, David Akik. I'm a senior resident judge, now running the Uganda circuit. I was once a student here, and I left in 1988. And joined the Department of Public Prosecutions before I became a magistrate, grade 1 in 1990. I'm happy to be back home. The little I knew about this was HURIPEC, Human Rights, and SASCIVO, South African Coordination. This is the second Moot I'm presiding at. I'll be happy to hear how you are reasoning on women's rights as human rights, because that is my master's degree.
You can continue on the right.
Good afternoon, ladies and gentlemen. My name is Jean Rakakoko. I'm a High Court judge now in the Family Division.
Became a banking officer, revenue officer with URA, an environmental lawyer with NEMA, and now I'm here. Lillian is my classmate, Lillian Adrico Bierogava. Good to see you.
Good afternoon. Wow. Lawyers, good afternoon. Good afternoon. My name is Olive Kazari Mukwaya. I'm a judge. I sit at the Land Division of the High Court. We were supposed to share when we were here. I left in '98. And good luck to you. Best of luck.
Good afternoon. I think I'm the youngest here. But I'm happy. I'm not that young. I'm happy to be back to my alma mater. I graduated from law school, Makerere University in 2001, with your current principal, Professor Naruwairo. I'm a judge of the High Court, Land Division, and I chair the Technical Committee of Electronic Filing of Cases in the judiciary. Nice to see you, and wishing you best of luck at law school.
So thank you, my brother, my sisters, for those introductions. As you can see, we've started a little bit late, so we are going to be very strict on the time. We understand you are the finalists, okay? You're the finalists after a rigorous competition, so fortunately or unfortunately for you, you are the creme de la creme. So we expect some good quality submissions. We are running this Moot with some ground rules. I'm going to go straight into that. We have come up with some rules that I'm sure you've been through Moots before, so these are not going to be very new. We want complete silence, some respect from the people who are in the plenary. You begin by, please switch off your phones. If you have forgotten to do so now, because we don't want somebody to come and confiscate your phone. So we expect silence in the court to allow these people to be able to think We are going to have strict timelines to you presenters. We know that we have a petitioner. Which is the petition side? Who are the petitioners? You are the petitioners. The appellants, sorry. The appellants and the respondents, yes. So, appellants, you are going to have 20 minutes. We want to wrap this up in exactly 50 minutes. You have 20 minutes. And we don't know how you plan to do it. If it's 3 of you, each one is going to make a presentation, divide your time accordingly. We are not going to allow you more time, so you must work within that time. Similarly, the respondent will have 40 minutes. 20 minutes. And since you have to rejoin as the appellants, we shall give you an extra 10 minutes to rejoin. Some of the other ground rules, we expect etiquette and proper decorum in court. Respect the bar, respect the bench, respect the judges when you are speaking to us. I think you heard her when she said, I'm speaking to lawyers. We expect to hear you. Okay, so speak loudly, audibly, but not shouting, of course. And be precise and concise in what you are saying. And then, of course, respect your colleague. Allow them to make their points. You are allowed to make objections, which is the way things run in a trial proceedings. But keep it to the minimum. You'll be allowed to raise those objections when you stand up to speak. I'm pleased to see that you all seem to be quite properly attired. I don't see my friend there in the middle. I'm a bit confused about your flaps. Didn't you see what your friends are dressed like? That counts a lot. Always do what others are doing. In our dress code, we are still quite conservative. So silence in court generally until somebody has finished. At the end of hearing both of you, the court will retire as it normally does. And we shall come up with our verdict. Please remember this is a moot. So we are not here to really delve into who has won the other, what were the court decided this or that. That is not what a moot, that is not, I think, the primary meaning of a moot. The moot, we need to know how well you've understood the question and how well you've articulated, how well you understand the facts, and then addressing the law to the facts. Those are the things we are going to be looking at mostly. But at the end, we shall come up with recommendations, and of course, the person who takes the prize. The prizes are right there before you, so work towards the prize. I know that many of you are supporting your colleagues, and you have been part of the long journey, but allow them space to present. So some of the things we are going to look at, I don't know if your lecturers have already told you, but just to let you know, some of the things we are going to be looking at is accuracy of legal analysis and application of facts. That takes quite a big chunk, 30 marks. And then quality and extent of research, I think that is already covered by the submissions you presented before us, another 30 marks. And then clarity and logic of argument. By the way, they've given it 10 marks, but personally, it's a very important thing because you will lose the court if you don't do it properly. You might have very good points, but you lose the court. Creativity in thought takes another 10 marks. Then ability to communicate with the bench takes another 10 marks. Your persuasiveness and fluency. Persuasiveness, as lawyers, we don't expect you to beg or to become very emotional. I know this is an emotional topic, but professionally, you act in a certain way. Let us see how you act. Then ability to respond to the opposing side's arguments. Very important. How do you rejoin? How do you rejoin? We don't expect you to say, you have only 10 minutes. So you're really going to be looking at what have they raised that you think you can persuade us otherwise. Don't repeat what you have said. So with that, I'm going to ask if any of my brothers or sisters or brother here have anything to add. and then we shall go into the moot. So we have kind of summed that up. So who is going to help us with timekeeping? Is it you, ma'am? You're helping us with timekeeping. You have heard. So please alert them with little cards to know. Part of good professional presentation is timekeeping. When the judges ask you and give you a certain amount of time, do it within that time, or better, less, but be effective. Don't be too wordy, because you'll be cut short before you come to the main part of your submissions. It's an art that we want you to learn. So without much ado, and maybe another piece of advice, you may take it, you may not take it. We think it might be useful for you when you begin to make a little introduction, to give us a little introduction into your case. Introduction statements, what we call opening remarks. You can choose to do it in 1 or 2 minutes, and it must be effective, and then you go into the body. And then you may choose or you may not choose to give us concluding remarks. The concluding remarks might help where you have run out of time, and you kind of want to bring everything to the fore before you're asked to stop. Thank you very much for listening to us. We are now going to session. We can begin. I hope they have taught you how you introduce yourselves to the court. Those are things you have done as you fought your way up to the top. So we shall allow the appellant to make their submissions for 20 minutes. And then you write the name on top. You may begin, ma'am. And you may need to tell us how you're going to present the appellant's case. Who is saying what? I mean, are you all going to present, or one will do so in rejoinder?
May it please this honorable court, I am Counsel Amanya Belinda, appearing with Counsel John Isaac Ochuo, Counsel Nakalule Hajara from M&S Legal Aid Clinic, appearing for the appellant.
Can you repeat Hajara's name?
Counsel Nakalule Hajara. Your Lordships, I will request the respondent lead counsel to kindly introduce the respondent counsel.
May it please this honorable court. My name is Akankwasa Isabel.
Can I just interrupt you for a minute, and I want to just speak to one of your lecturers, the one in charge. There's a small clarification we forgot to make in private. You may sit down, we shall count your time. Been sorted. We have seen the columns. Every oralist gets a mark. So They'll find their level. Now we're on Good. Thank you very much, Ms. Amanya. You may begin. Your time starts now.
May it please this honorable court. My name is Akankwasa Isabel, alongside my co-counsels, Miss Evelyn Semere and Mr. Gabriel Ejai.
Oh, sorry. I didn't allow. Yes, you're correct. We need you to introduce yourselves. Good.
My lordships, we have been awarded 20 minutes and additional 10 minutes for rejoinder. However, we pray to use 10 minutes for resolution of the first issue, 10 minutes for resolution of the second and third issue, and 6 minutes for the resolution of the fourth issue and the prayers, and then reserve 6 minutes, and then reserve 4 minutes for the rejoinder.
You're asking for more time?
No, she wants to she's dividing.
To change.
We told her to ask, give you the breakdown.
Okay. And that fits in your 20 minutes?
Yes. Most obliged. My lordships, the matter before us arises from High Court Divorce Clause 34 of 2022 under Article 134 of the Constitution of Dakala, Section 66 of the Civil Procedures Act, and Section 10 of the Judicature Act of Dakala, thus granting this honorable court jurisdiction to hear the matter before this honorable court. My lordships, I request to proceed to my opening statement. My lordships, 88% of the women...
let's use the correct English. My lords, your lordships. My lords or your lordships.
Most obliged, my lord. Your lordships, 88% of the women in Dakala, compared to 78% of the men in Dakala, are engaged in the informal sector, which is the agricultural system of the economy. These women are expected to devote more extra 10 hours of their daily work, of their daily time, to devotion to the agricultural needs. Unlike their male counterparts, even when a normal human being has 24 hours a day. My lords, more to this, at dissolution of marriage, their contribution is always held negligible and never valued, to an extent that women are treated as donkeys and camels that work for their masters, and at the end of the day, left with nothing but pity and sorrows. My lordships, my lords, the matter before us today is of a lady, Rita Izome, who has been married to Robert Okoye for the past 16 years. She has devoted her time, her effort, her mind to the growth and development of the family property and of the family in and itself. My lords, in paragraph 10 and 11, it is clearly stated that Rita Izome has contributed to the clearing of the land, contributed to the building of a 5-bedroom house, contributed to the tilling of the land, contributed to the management of the harvesting and selling of the vanilla. She has proceeded to also manage the home and family, and also managed house chores as a lady. More to that, adding more extra 10 hours a day to the field work she has to execute. But my lords, at the point of dissolution, the trial judge decides to grant 20% of the value of this property to Rita Izome, which we do contest with and find it an injustice to Rita Izome. More to that,
Ms.
the trial...
Amanya, are you still on your opening remarks?
I have proceeded to the facts, brief facts.
You should say so when you do, because
Most
I thought you were
obliged.
still introducing the problem. Thank you. Go ahead.
More to that, the trial judge has held that Rita Izome does not have any right to ownership of the property in question. My lords, this honorable court has been granted the authority and mandate to reinstate the position of women like Rita in Dakala. Reinstate their value, their contribution, which needs equitable and equal valuation and consideration, especially at the point of dissolution of marriage. Your lordships, the appellant arises under 2 grounds. However, during the scheduling conference, parties agreed to 4 issues, and I will proceed to resolve issue number 1. Issue number 1 being whether the trial court's decision that the appellant is not entitled to any share of the property on which her and the respondent's matrimonial home was situated is in contravention of the legal provisions relating to the right to freedom from discrimination and the right to property in the Land Act and the Constitution of the Republic of Dakala. My lords, I request to proceed under 2 head arguments. Argument 1 being that Rita Izome, the appellant, has a right to belong to the Okoye family. And argument 2 being that the trial judge used customary law to decide on this case, which according to section 27 of the Land Act Cap 236 is inconsistent with the Constitution of Dakala per Article 2 of the Constitution of Dakala. My lords, Article 31 of the Constitution of Dakala speaks to the fact of equality at marriage, during marriage, and at the dissolution of marriage. Article 26 proceeds to state that everyone has a right to ownership of property, whether jointly or individually. To the extent of what is prevailing in the case, to the extent of what is prevailing in the facts at hand, it is realized that Rita Izome is held not to be a member of the Okoye family. Yet in the case of Ambayo Joseph versus Aserua Jacqueline, divorce cause number 3 of 1988, it was held that direct and indirect contribution should be valued and assessed in the ownership of property. Furthermore, in the case of Hawa Mohammed versus Ali Saif of 1983, it was rightly held that contribution to property makes one entitled to that property. It has been outrightly put that the contribution of Rita Izome has been pushed aside to the dust, to waste, even after she has been in marriage for the past 16 years, devoted her time, her effort in developing family and also the family property. And to that extent, would like to nullify the point that she is not a member of the family. Yet, in the case of Wenman versus Ash, it is held that when a man gets married to his wife, they become one. And in the case of Nachiinji versus Melchizedek, it is also held that the husband hold property in trust for their wives, which to this extent only proves that Rita Izome is party to the property in question by virtue of her contribution and by virtue of her marriage. My lords, proceeding to the trial judge's decision, which resides under customary law. Section 3 of the Land Act, Cap 236, proceeds to inform us that customary land shall be adjudicated by customary law in the land. However, Section 27 of the same Act proceeds to put an exception, which states that in cases or in circumstances where that law is discriminatory to the rights of women, then it shall be considered null and void as it is stated under Article 2 of the Constitution of Dakala. We would like to proceed to back this up with Article 33, which speaks to the protection of the rights of women and equality of women in Dakala. My lords, paragraph 13, my lords, paragraph 13.7 speaks about the Tonga culture, which is the customary law governing Dakala. The Tonga culture, which speaks to the fact that women in Dakala or women from the Tonga tribe do not have any rights to property. Be them children, be them wives, they are pushed out of the equation of ownership of property, which is inconsistent with the said Article 2 of the Constitution of Dakala and Section 27 of the Land Act of Dakala. Article 8 of the Maputo Protocol proceeds to assert that there should be access to justice and equal protection before the law. This in the same way encompasses the right and protection of women such as Rita in the right to ownership of property. Furthermore, we also get to realize that the trial court's decision is a highlight of the high levels of misogyny and patriarchy that exist in Dakala, in the Dakala country, and therefore, as the appellant, we proceed to pray that this honorable judge may. In conclusion, we pray as the appellant that this honorable court grant ladies like Rita Izome the rightful value, the rightful protection to their rights of ownership, regardless of what the customs say and the customs speak that are in line with misogyny and patriarchy. We also continue to pray that the matter before us is judged in line with the Constitution and not customary law, which is creating a huge injustice to women in Dakala. And finally, we proceed to pray that Rita be counted as a member of the Okoye family by virtue of her contribution and the amount of time she has spent in her marriage.
And how much time do you have?
My time is used up, my lord.
Timekeeper? How much time do they have of their 20 minutes? Good. Well done.
I want to suggest how you have a lot to do in the 10-20 minutes. Okay. So hand over to the other.
I would like to relinquish the floor to my co-counsel to proceed on issue 2 and 3.
Relinquish the floor. Thank you.
May it please this honorable court, for the record, I am Ochuo John Isaac, and I will be proceeding with handling issue 2 and 3 before this honorable court. Your lordships, as required by issue 2, it seeks to establish that whether the trial court's decision not to grant the appellant 50% of the matrimonial home on which her and the respondent's matrimonial home was situate is a contravention of the right to equality at marriage, during the marriage, and at dissolution of the marriage, and the right to property. Your lordships, we submit that the right to equality in marriage is protected under Article 38, Clause 1 of the 1995 Constitution of the Republic of Dakala, and equally the right to property is protected under Article 26 of the same. Your lordships, it is our submission that the requirement to strictly prove contribution to the development of matrimonial property by way of receipt is too strict and actually does...
Can you repeat that, please?
the statement. It is a submission that the requirement of strict proof to prove contribution to matrimonial property by way of receipt is in violation of the principles of equity and justice and the right to equality as well. Your Lordships, under our Article 126, Clause 2, Paragraph E, it is noted that substantive justice should be given or availed to a person without undue regard to technicalities. Your Lordships, the word undue could be defined to mean unnecessary regard to technicalities.
Technicality, the custom?
Your Lordship, the technicality in this matter is the requirement for receipts to prove contribution to matrimonial property. And it is our submission that it becomes unnecessary, especially where there is alternative evidence to prove the same. Your Lordship, it is a submission that in accordance with...
Just a minute, that means it is about documentary evidence versus oral evidence. Is that your argument?
Yes, Your Lordship. The Honorable Court, in deciding to deny the appellant a 50% share based on the fact that she did not produce receipts, and it is a submission that there was alternative evidence to prove the same. Your Lordship, when we look at Section 16 of the Evidence Act, it points to the fact that an admission is evidence to prove a fact in issue or in question. And Your Lordships continue, this admission is self-incriminating in nature and is actually biased against the person who makes the same. And this is proof already, as seen in paragraph 17 of the fact sheet, that the respondent, Mr. Robert Okoye, acknowledges that Rita has contributed to the matrimonial property, has actually contributed to the payment of the workers, has done lots of other things towards the same. And Your Lordship, it is a submission that by requiring to strictly prove by way of receipt, there was a miscarriage of justice and a disadvantagement disproportionately against the person of Rita Izoma. Your Lordship, it is equally a submission that in the case of Rima versus Rima, the Court of Appeal of England seemed to advocate for a laxity when considering the rights that are between married persons. And Lord Justice Roma noted that cases between husband and wife ought not to be governed by the same strict considerations as those that are against or between persons that are strangers. And Your Lordship, it is a submission that Robert Okoye and Rita Izoma have been married. And the need for receipts, the marriage has been subsisting for 16 solid years. And it is a submission that, considering that there should be a laxity when considering these issues, we pray to this Honorable Court to look into the other sets of evidence that are available to prove the same fact, rather than neglect everything altogether. It is equally a submission, Your Lordships, that this Honorable Court, the trial court, neglected to consider the contributions in form of non-paid care, which was actually done by Rita Izoma. Your Lordships, the case of Ambayo Joseph versus Aserua Jacqueline points to the fact that contribution to matrimonial property can be direct, and that is to say monetary, or indirect in the form of non-paid domestic care, which is defined to encompass all forms of work that are done by a person to a marriage or by a married person that are not compensated by wages. Paragraph 11 is clear that the appellant has been tilling the land, she has taken care of the family, she has cooked for them, bought and paid, bought grocery, paid, and so many other stuff that she has been doing. Your Lordships, it is a submission that...
And you avoid using words like all other stuff.
Much obliged, Your Lordship. It is a submission that by neglecting to look at the non-monetary contribution, there was a miscarriage of justice, as equally this is contribution towards the development or acquisition of matrimonial property. Your Lordship, I will proceed with handling issue 2, which is to the effect that, issue 3 rather, which is to the effect that the requirement or the awardment of the appellant only 20% as value for her non-monetary contribution is actually a violation of her right to equality in marriage, even at the dissolution of the marriage. It is a submission that in holding or coming to this particular conclusion, the land trial judge only looked at the fact that there was, did miss out to consider some other factors that need to be considered, as required in the case of Rabinumi versus Bahimbi Somwe. There it was noted that in quantification of non-monetary contribution, some factors need to be looked at, and that is to wit, the length of subsistence of the marriage, the life expectancy of a spouse, and to also include the monetary contributions, your lordships. It is a submission that by neglecting to look at all these other factors, there is likeliness, which has actually happened, that there has been a miscarriage of justice since some factors have not been considered, thereby causing the appellant to be awarded only 20%. Your lordship, it is a submission and a prayer that this marriage has been subsisting for 16 solid years, and amongst all, throughout which Rita Izoma has been contributing to the development of this property. And by neglect of this, there is a miscarriage of justice, which it is our prayer that this court resolves.
Mr. Cho,
please.
You're saying that the 20% was insufficient?
Yes, your lordship.
Given your submissions, what would have been the correct percentage?
Much obliged, your lordship. The correct percentage is a 50% share.
Again, the argument of the judge, or the belief of the judge, was this is communal land. Your colleague talked about custom. We have custom in our constitution. And he's saying, look here, there's this custom. This land belongs to the clan or the community of the man. I haven't had so much your thoughts on that.
If I may submit on the same.
In 1 minute.
Your lordships, Section 27 of the Land Act requires that customs that are customary, customs should be applied on customary land insofar as they are consistent and they do not cause a disadvantage towards women, children, and marginalized groups. It is a submission that that particular custom belonging to the Tonga tribe, that ladies are not, or women are not supposed to hold property or in any way, is actually not applicable in this particular situation.
You are very articulate, but are you quoting the right article section?
Well, unless
are you able to read it out?
Unless the facts change the articles. Yes, because it was a hypothetical question, so we are a bit confused.
Your lordships, Section 27 provides that any decision taken in respect of land held under customary tenure, whether in respect of land held individually or communally, shall be in accordance with the customs, traditions, and practices of the community concerned, except that a decision which denies women or children or persons with disabilities access to ownership.
I want you to convince us how, if the custom says that this land cannot be owned by individuals, it's owned by the community. So now how does this woman get individual ownership? How do you harmonize those two positions, the contradictions?
Your lordship, the custom says that women cannot hold any share of the property.
Remember, it's that the community is the one which owns the land. How do you marry those two? It's not individuals. It doesn't say that the man owns the land.
Your lordship, we also submit that this is customary land, but also continue to aver that in one of the prayers, it was a prayer of the divorce clause number 34 of 2022, which the parties were, party 2, which is being appealed, that also an order, as alternative, an order directing Robert to pay her half of the value of the property could be made. So even when the property cannot be given out, half of this can be paid to her to compensate for the 16 years that she has labored to improve this land.
Half of what?
Half of the value of the matrimonial property.
So you want Robert to sell it to, and remember it's not his? How do you make this remedy practical and enforceable?
Robert is a young man. who...
Can I ask a follow-up question? How do you arrive at the 50%?
Much obliged. To first respond to your ladyship's question, Robert can work as a young man and pay Rita Izoma for her property, or else agree to use the land together with her, as it has been in the 16 years. The options are to him, for him to decide. If this honorable court permits that, could you please pardon the question, Your Lordship?
How do you arrive at the 50%?
I'm much obliged. Your Lordship, to arrive to the 50%, we are quantifying the non-monetary contribution that has been done for the 16 years in form of non-paid care, and also additionally adding the other monetary contribution that Robert Okoye does not refute or makes admission in regards to the same. And that's so as to arrive to the 50% that we are praying for before this court.
Thank you. I think you've exhausted your time, but just one quick one. I may have missed it. I want to know, what do you want the court to do? In 3 words. I mean, what orders are you seeking from us? That wasn't very clear.
It is our prayer.
Okay, perhaps you should always be alive to the theme of this moot. We are closing a gender gap. We are suggesting reforms. Okay? Reason it that way.
What do you want the court to do for you?
Our prayer to this honorable court is for proper valuation of Rita's contribution, to extend it from a 20% to a 50% after all the other factors have been put into consideration. Our other prayer is that this honorable court to make a pronouncement on itself in regards to the rights of women, so as to not set a dangerous precedent that will be exploited by misogynists and people who seek to downplay the rights of women before this honorable court.
Thank you very much, sir.
Much obliged.
Unless there are any questions for you?
Just a quick one. I know you've just told us what you'd want this court to do, but it seems to me like the arguments that you have on the 50-50 is based on the constitutional argument of equality. So is that the basis of the 50-50, that men and women should be equal both in marriage and in property ownership?
Your Lordship, we are not basing on a 50% share of the property, knowing that marriage does not actually automatically guarantee a person to 50% share to matrimonial property. But rather, we are praying to this honorable court to put into consideration all the other factors that were neglected by the trial court, and thereby arriving to a decision that could be owned by this honorable court, that is rightful and has considered all the other factors, so as to arrive to a decision that upholds the rights of Rita Izoma with no biasness.
Thank you very much, sir.
My lord, just last one.
Good.
Do you realize when you say all other factors that you're so ambiguous? Because if you have to justify a certain percentage, you should actually articulate what those factors are. If you were to bullet them, you would be saying, I need you to consider that the trial judge ignored this, ignore that, and that. And that will surmount to around 50% or whatever you would like us to believe.
Much obliged, Your Lordship. Just to re-echo, the factors were that the monetary contribution that is not in contention, that has been admitted by Robert Okoye, be put into consideration. Secondly, that the length of the marriage be also considered. This has been 16 years of marriage. Thirdly, the life expectancy and sustainability of the appellant after the dissolution of the marriage. These factors should be put into consideration, Your Lordship.
Give the other side an opportunity. You may sit down. Thank you very much for... I imagine your friend is going to rejoin. Yes.
Much obliged.
Now we shall turn to the respondents. You know your time and you know how you have... But they have not been... Allow me to go back to you. I thought you have concluded. You had another? You do? Were you asking for the 4 minutes beyond the 20? Within the 20?
My Lordship, we had requested that for the 10 minutes of the rejoinder, we borrow 6 and then retain 4 for the rejoinder.
We shall give you 2 minutes.
May it please this Honorable Court, I'm Counsel Nakale Hajara, and I'll proceed to our prayers to this Honorable Court. Your Lordships, it is our prayer that this Honorable Court be guided by the case of Fazana Sensio of Begumisa and 3 others versus Eric Chibebanga, civil court case, Your Lordships, it is our
in
prayer.
court, we take a deep breath. You can take a sip of some water. It works.
Good.
Your Lordships, much obliged. It is our prayer to this Honorable Court that it be guided by the case of Padana Sensio Begumisa and 3 others versus Eric Chibebanga, case appeal number 17 of 2002, as the first appellant court to appraise the evidence being adduced, as well as the matters being raised so as to make its own decision regarding our matters raised. Your Lordships, it is on this basis that we pray to this Honorable Court that finds the appellant really entitled to the relief sought.
It's in Article 134, Clause 2 of the Constitution of the Republic of Dakala. Rule 30 of the Judicial Court of Appeal rules is to the effect that this Honorable Court has the duty to rescrutinize evidence and come to its own conclusion. The matter before us, my lords, is not an infringement, is not a question of the infringement of human rights. It is true that in the Republic of Dakala, women, there is patriarchy. When we look at the facts, it is clear there is patriarchy. Women do not have the right to inherit land. Women do not actually have the right to own land. The property in question is customary land. However, this is a court of appeal matter, and we are actually here to decide and question, did the decision of the trial court hold water? Was it right? Did it dispense justice to the appellant? The appellants assert that the first point of the appellant's assertion is that the appellant has the right to belong to the Okoye family. The matter before this court is not whether she is a family member or not. It is a question of customary land, property rights of women, matrimonial property, equality, discrimination, and customarily owned land. When we look at the decision of the trial court, I would like to draw this honorable court to the reasons why the judge actually gave his decision. When you look at the paragraph 18 of the facts, it is clear that he takes not only paragraph 18 and 19, it is clear that he not only takes cognizance of domestic law, but international law. The appellants assert that there has been an infringement on the right of equality and property rights. However, we seek to aver, using Article 45 of the Constitution, that is Article 45 of the Constitution and Article 27, Clause 2 of the Maputo Protocol, that are to the effect that in the enjoyment of rights, due cognizance must be actually taken to other human beings. What are the facts before us? There is a woman, there is divorce. It is actually a nasty matter, but the trial court looks at the fact that the people of Tonga have those rights, these land rights that have been established, and the appellant also has her economic right to use land. He therefore grants her 20% value of the customary land. I actually the appellant, the respondents seek to assert that the matter in question is not only a fragile matter, but the judge takes cognizance of customary law, human rights. The duties of court is actually to give justice, especially to vulnerable groups of people. But the question of equality and discrimination are given by the United Nations Committee on Human Rights that give us the normative content and the standard that a state has, the standard of obligation that a state has to meet before actually a state can actually, in its laws or in an act of justice or in a ruling, say that they have infringed on these rights. What are these? One, that there should be full participation, inclusion, and consideration of the differential decisions. The trial court will seek to assert, my lords, that the trial court consider that this is customary land, as is clear in the facts paragraph 3, and secondly, that she has land rights and gave her 20%. My lords, on the fact of discrimination, discrimination is defined in the Universal Declaration of Human Rights, and the general comment gives us the test and what a country needs to, what an action would do to amount to discrimination. What is this test? That the authorities...
Sorry, which general comment are you talking about?
Much obliged, my lord.
General recommendation?
A recommendation or a comment?
Much obliged, my
on
lord.
On what, anyway, if you can't remember the actual number?
It's on the Universal Declaration of Human Rights, which is, as Dakala, as a dualist state, recognizes its role in international law.
Go ahead.
Much obliged, my lord. We therefore consider and we therefore assert as the appellants that one, the test raised by the respondents that she should be part of the family is not relevant to the issue in fact, and secondly, that the appellants assert that the matter infringed on her constitution, that the matter is inconsistent with the constitution, where they quoted the Land Act, inter alia the constitution. We are seated before this honorable court as Court of Appeal, and Court of Appeal is enshrined in Article 134. It does not sit as a constitutional court. If this is a matter that the custom is inconsistent with the constitution, the honorable court will sit as the constitutional court and give us a decision on the same.
So you mean as an appellant court, we don't consider the constitution?
Much obliged, my lord. I only assert that this is not a matter of constitutional interpretation. It's, however, a matter of appeal that is to question the decision from the High Court as enshrined under the Judicial Procedure Rules, Section 1, 2, and 30, that is to the effect that this court has a duty to scrutinize evidence and come to its decision. Much obliged. If I should continue, much obliged, I beg to continue. When we look at the African Commission decision of Serac versus Nigeria, it discusses the rights of the bundle rights of a custom. Justice of a community, my lord. Much obliged. Justice, and it is to the same effect that Justice Mubiru in Omalusi versus Chidega Moses, a civil appeal case, discusses the usufructory rights that arise from communally held land and how communally held land should be discussed in the matters of courts. The test is that even though it is communally held land, there are still individual usufructory rights on it. This test is discussed as common property, as Justice Mubiru discusses. And second, and more so, we would like to use the test of customary v. matrimonial property. Because there are usufructory rights on this land, the bundle rights must be considered, as it's the state obligation to consider the customs. However, it's also the state obligation to consider the vulnerable groups of people in the Republic of Dakala. The appellant, Ms. Inzoma, does qualify as a vulnerable group of person, and her rights have been duly considered in giving her 20% of the value of this matrimonial property.
Why 20?
Much obliged, my lord. When you look at the facts before us, we would like this honorable court to refer to paragraph 10 and 11 that discuss in extensiveness the contribution of the husband and the wife. This is a couple. They have actually broken up, and court says let the father actually take care of the children, and let the woman, let us give her an economic right. Because it's true that in divorce, women are left fragile, they are left helpless. But the trial court's decision does not infringe on her rights. It does not raise to the standard of the infringement of discrimination or inequality.
Let us be sure, as a fact, who took custody of the issues of marriage? The children are given to the wife, right?
Much obliged, my lord.
Custody is given to the wife.
Much obliged,
Maintenance is not determined. It's just said maintenance. And the other man is taking 80%. Is he going to breastfeed?
Much obliged, my lord. I would like to refer us to paragraph 15 of the decision of the High Court, that is to the effect that he gives the parties. I pray for a minute to finish my statement.
Okay, you are borrowing, you are lending, you are losing a minute. Prepare yourself.
I would like this Honorable Court to refer to paragraph 15 of the decision of the High Court. It gives the parties divorce. It gives joint custody for the children as discussed in family law. It gives maintenance of the 4 children to the respondent, my client, Mr. Robert Okoye. Maintenance will be discussed by my next counsel, but it is also to the effect that when you're maintaining 4 children, there is a standard, there is a level of income that you need. It also gives equal distribution of matrimonial property with either physical division, and Rita is given half. This is much obliged, my lord. So, if the trial court...
Just a minute.
Yes, ma'am.
What you are referring to as paragraph 15 is paragraph 18.
Yes, my lord.
That is where the orders of the trial judge are.
Much obliged, my lord. I would like this honorable court to also look at paragraph 18. I beg to rescind my statement. I would like this honorable court to look at paragraph 18 and also the last line of paragraph 11, that is to the effect of how this marriage actually existed to its extent, because married people, as court actually holds, that matrimony is a sacred matter. Justice Twino Mujisha discusses the same, and it is respected. However, at its dissolution, court must actually take a stand on who to favor. But in this matter, it does not actually favor the respondent, as the appellants might actually assert. It not only favors the people of the Tonga, who have usufructory rights on this land, but it also favors the respondent in his role to take care of his 4 children and gives an economic right. It bridges that gender gap. Dakala has that weakness, actually.
You can answer briefly, please. You have 1 minute. Thank you very much.
Much obliged. We pray to this honorable court that this matter will be dismissed.
Are you making the prayers before we conclude? Let's first hear from your colleagues, then that will come as the conclusion.
Much obliged, my lord.
Yes.
Thank you.
And maybe we just need to know quickly, you didn't tell us at the beginning, are you both going to speak? And so tell us what you're going to talk about and what he's going to talk about.
Much obliged, my lord. In the 20 minutes that we are taking up of this honorable court's time, I will use 6 minutes to discuss issue 1. Miss Evelyn Nsemere will use 4 minutes to discuss issue 2, and Mr. Gabriel Ejai will use 6 minutes to discuss issue 3 and pray to this honorable court.
So she has 4 minutes?
Yes, my lord.
Thank you.
Much obliged.
Much obliged, your lordships. May it please this honorable court, Nsemere Evelyn Angela for the respondent. Yes, Nsemere Evelyn Angela for the respondent, Robert Okoye. In 4 minutes, I'll address this honorable court on issue 2. Respondent recognizes that in the state of Dakala, there is a systemic disregard for women's rights to property, especially at the dissolution of marriages. But we stand here to defend the trial court's equitable distribution of the property in question. Your lordships, issue 2 is to refute the appellant's claims that the need for documentary evidence from the appellant to prove that her contribution to the matrimonial property was 50% of the value of the property is a violation of her right to freedom from discrimination, equality at, during, and upon the dissolution of marriage, and her rights to property enshrined under the Constitution of the Republic of Dakala, under Articles 21, 31, and 26.
And how to summarize? We heard him. You are eating into your time.
Much obliged, Your Lordships. We refute this issue in twofold. First of all, that there was necessity for the trial court to require for this evidence. And secondly, that even without documentary evidence, the trial court took into consideration the appellant's rights, assessed using an objective standard, and awarded her accordingly. Your Lordships, under my first head of argument, we argue that there was necessity for the appellant to produce documentary evidence, and this is the standard in Section 101 of the Evidence Act of the Republic of Dakala. It asserts that whoever has an allegation must provide evidence to prove that allegation. The burden of proof is on the person who alleges. Your Lordships, the appellant alleges that her contribution to the property is 50% of the value of the property, and in giving this requirement, the trial court sought to apply an objective standard to establish that indeed her contribution to the property was 50%. Your Lordships, courts cannot disregard the aspects of
just
procedure.
a moment.
Much obliged.
Your very last submission was in regard to the Evidence Act and that whoever alleges must prove.
Yes, Your
and you
Lordship.
seem to connote that the proof should be by documentary evidence. Is that so?
Your Lordship, the need for this documentary evidence is an aspect of procedure, and it was only needed to prove that the appellant's contribution was 50% of the value of the property.
Is that the only way one can prove? If someone has been doing all the work that the appellant has been doing at home, how do you expect her to prove by documentary evidence?
Much
that
obliged, Your
contribution?
Lordships. The trial court, after recognizing that it was practically impossible for the appellant to produce documentary evidence, still had regard to her rights in the Constitution of the Republic of Dakala and in international law, including the Convention on Elimination of All Forms of Discrimination Against Women and the Maputo Protocol, and applied as the standard laid out in the case of Ambayo versus Aserowa, which is that when assessing non-monetary contribution to matrimonial property, that courts assess the value of the property, the value of the work given, contributed to the property, basing on the availability of the same work on the local market. Your Lordships, throughout this, we see that the trial court applied an objective standard, that even without documentary evidence, they maintained their stance, that they applied an objective standard, went ahead to assess the contribution of the appellant using the value of the same property. This is reflected in the facts on page 8, paragraph 19. We see what the trial judge took cognizance of, and that they took cognizance of the appellant's rights and her non-monetary contribution to the property on which the matrimonial home was situated. Your Lordships, I recognize that my time is fast spent. And
yes, Counsel, I'm amused that one gives 20% and you say it was assessed. Assessed on what basis? Or it was given arbitrarily?
Your Lordship, it was not.
Is there any form of assessment arriving at 20%?
Yes, Your Lordship. This assessment.
Chicken, potatoes, what?
No, Your Lordships. The assessment was an assessment of unpaid care work by the appellant, and it was assessed basing on
work, unpaid work. That's the assessment I'm asking. You could say cooking, 1 shilling. Washing clothes, 2 shillings. How did they arrive at 20%, that assessment? Did you see it in the judgment? It was an arbitrary award by the husband. Say, I think you deserve 20 here, 20.
No, Your Lordship. First of all, this award was not given by the husband, it was given by the trial court, which trial court went and assessed the availability of unpaid care work in form of paid care work. Your Lordship, I'm assuming that this is unpaid care work now, when transformed to paid care work, is the work that a house help gives. She washes clothes, she looks after the animals, she looks after the children.
Do you want to refer to the judgment when you're making your submissions? At which part of the record did that happen?
I beg your pardon, Your Lordship.
Refer to your in your
To the
records?
judgment.
The judgment.
Specifically look at paragraph 18, part B. That was the decision of the judge. What did the judge say in paragraph 18B?
That Rita Izoma did not provide any documentary evidence to show her contribution to the development of the property on which her marital home was, Robert Okoye, was situated.
Mm-hmm.
She therefore did not prove that she contributed half of its value towards its development during the marriage, and therefore
Yes,
not
but did she
entitled
prove that she
half.
contributed 20%?
No, Your Lordships. She did not prove the half. She did not prove that she contributed half.
Not
but the
20,
trial.
Not 20, not 50.
Not 50, but she was stating that she's entitled to half of the value of the property, as stated in this very paragraph.
So the 20 was a token. The judge said, okay, let me give you something.
The judge had due regard to her rights and had due regard to her rights, first of all, and her non-monetary contribution, which widely in Africa and communities is disregarded by many communities, and this is reflected in General Comment number 6 on Article 7D of the Maputo Protocol. Your Lordships, by recognizing the appellant's rights and her non-monetary contribution, the trial court went ahead and assessed, applying the same objective standard on which it insisted from the very beginning, and awarded the appellant accordingly.
Thank you very much. Thank you. Yes, and do you have another question, Judge?
If I'm of no further indulgence, I sit.
Thank you.
Just
wait for that question, please.
It's not a question, my lord. I just wanted to ask Ms. Nsemere to look at paragraphs 18 in tandem with paragraph 19 of the judgment. The judge just said, we are not attaching any specific market value. And that is, he said, just these contributions at 20%.
No, Your Lordships, that is not true.
Mhm.
In the facts,
Prove.
Yes. On that very page, page 8, paragraph 19. Paragraph 19, starting from line 3, he stated that in line with the obligation of the Republic of Dakala to promote the rights of women as espoused under the CEDAW, the Maputo Protocol, and the Constitution of the Republic of Dakala, he then stated that when assessing the value of unpaid care work, due consideration should be given to the price at which similar services are available on the market.
And when you go ahead at paragraph 9, line 3, where it starts, he, however, can you read that?
Paragraph 9, line 3.
Page 9.
Page 9.
Page 9.
On top, line 3, where it starts, it states, he, however,
did not indicate the specific market value that he attached to each form of unpaid.
Okay, so are you still going on to say that he attached value in the assessment?
Yes, Your Lordships, he attached the value, but he did not specify. He did not come back and say that this was what we found, but he only came back and gave the decision.
Generally.
What he arrived at.
Okay.
Much obliged, Your Lordships. I seek to cede the floor to the next speaker.
Thank you for holding your own. I know we have, given you many questions, and that is part of proceedings. Yes, sir. You have 6 minutes. Try and do it in 5, if you may.
Much obliged, Your Lordship. I will start by, may it please this Honorable Court. Gabriel Ejai Opolot is my name, appearing on behalf of the respondent, Mr. Robert Okoye. I will, however, start by saying that co-counsel had earlier stated 664, but it was actually 77776. And so if she used +1, so I have 7 minutes to present this matter.
Yes, if you can do it in 6, we shall be happy. But go ahead.
Much obliged, Your
My Lord,
Lordships.
before he starts, doesn't that sound like an assessment to you? What you've just done.
An assessment.
Remember, we are talking about the assessment of 20%. What you've just done.
It's an assessment, Your Lordship, but based off fact. 776. Much obliged, Your Lordship. Issue 3, the respondent contends that the trial court's valuation of the non-monetary contribution of the appellant at 20% infringed her rights. Under this issue, I'll handle this under the head of argument that the trial court did take in cognizance her non-monetary contribution and reached a valuable decision clearly, taking in cognizance her non-monetary contribution, and that this non-monetary contribution does not amount to 50%. I'll be handling this issue in direct response to the appellant's claims. Firstly, Your Lordships, the appellant contends that the counsel for the appellant contends that the appellant, Ms. Rita Izoma, contributed to the land. However, counsel forgets and does not include that in paragraph 10 of these same facts and 11, the respondent, Mr. Robert Okoye, was right there with her from the beginning. Paragraph 10 shows clearly that when they first moved to the house, they did this work together. And paragraph 11 is also to the same effect, that in paragraph 11 it says that the respondent did this work and hired helps and farm hands to help the appellant in doing the work on the farm.
And so much the reason for her to want 50%.
Much obliged, Your Lordship. Thank you.
You're getting there. Okay.
I'm getting there, Your Lordship. This is I'm proving that they did this work together. Secondly, Your Lordships, the appellant contended that in valuing the contribution, they should take in cognizance the facts. They stated the case of Ambayo, and the respondent concurs that yes, they should take in cognizance of the facts, because in determining distribution of matrimonial property, we should look always back to the peculiar facts of each case, and this was stated in Ambayo Joseph versus Aserua Jacqueline. Looking at the facts of the case, as I've already stated, paragraphs 10 and 11 show that the two parties did this work together and derived sustenance from it thereafter, and then valuations of the way the work was proportioned happened thereafter. Your Lordships.
Can you repeat that? You said valuations of the way the work was apportioned happened thereafter?
Much obliged, Your Lordship. The way they distributed the proceeds from the vanilla farm, Your Lordship.
Which was how?
It was 80-20, but I'm getting to that because for the 80% valuation that the respondent got, he had big tasks that were capital intensive and necessitated this 80%. These parties agreed. You see, Your Lordships, in distribution of property.
Can you please substantiate how or where in the facts you
Much
see
obliged, Your Lordship.
these big expenses?
Much obliged, Your Lordship. Let's go to page 5, paragraph 11 of the facts.
And on top of that, was it an agreement or it was a decision made by your client that I'm taking 20 and I'm taking 80 and I'm giving you 20? Is there any fact which proves that there was a consensus on the distribution?
Your Lordship,
And the facts show that agreements about money were one of the causes of the breakdown of the marriage, not so?
Yes, Your Lordship. However, when they appropriated the 2080, it was apportioned, pardon me, when they apportioned the 80-20, it was because, as I'm going, line 13 of the same paragraph 11, it's the last 3 lines, last 4 technically. Robert, who is the current respondent, on the other hand, would pay the school fees, Your Lordships, for not 1, not 2, not 3, but 4 children. He purchased seeds, materials, tools, and machinery. All of this derived largely back to what was gotten from the farm. without his input on this, putting back the money that they got from the same farm. This money is proceeds. It's net proceeds. This is without income or profit. It's the whole money. And he got this money and then took it back into the farm directly, in addition, Your Lordships, to paying for the farm hands. Your Lordship, this money was needed, furthermore, for maintenance. As earlier stated by co-counsel, maintenance is provided for in Section 5 of the Children's Act. And it states inter alia that it includes education for children, Your Lordships. Education, immunization, adequate diet, clothing, shelter, medical attention. And as earlier stated by Your Lordship, this was to be done by the respondent himself alone. The appellant wants to get 50% of this valuation, but she's only having joint custody, but doesn't take part in the maintenance of these same children. Yet, the respondent still is remaining with the, let's say, 50%. Your Lordship, the respondent avers that this was seen and that we should look at the facts of each case as per Ambayo Joseph versus Asera Jacqueline and PNN versus ZWN, a Kenya Court of Appeal 21 case where it was held that equality does not mean necessarily half of the property. Your Lordships, I realize my time is fast spent. I beg for 1 minute to submit my prayers.
1 minute.
Much obliged, Your Lordship. The prayers of this honorable, basing on Article 134 of the Constitution of the Republic of Dakala, which gives this court as the Court of Appeal the power to grant the remedies sought, and sections 10 and 11 of the Judicature Act and Rule 30 of the Court of Appeal Judicature Rules, the Judicature Act Court of Appeal Rules, and Father Nasensio Begumisa versus Eric Tibebaga. This honorable court has the powers to grant the relief sought, and thus the respondent prays that this appeal is dismissed and each party meets the costs of the suit, claiming that the appellant, further, Your Lordships, the appellant had earlier stated that this court has the jurisdiction using Father Nasensio versus Eric Tibebaga, but the appellant mentioned Eric Kibebanga. This is not the case, and thus she did not establish the jurisdiction. If I am of no further questions, I seek to cede the floor.
Very much, Mr. Ejai, for that response. The appellant has a right to rejoin. We have already briefly directed you on how to do that. You have 10 minutes. Can you tell us who is going to rejoin, whether it is 1 or 2 people? Who is leading?
It is I think.
You seem very unsure. Yes. The rejoinder is your last reply to what has been raised by the respondents.
Much obliged, Your Lordship.
How are you going to present? You
I
have 10
will
minutes.
solely handle the rejoinder.
Thank you.
Your Lordships, it was submitted that not being a member of the family, of the Okoye family, is not the matter that brings us to this honorable court. Your Lordship, it is our submission that not being a member of the Okoye family was one of the grounds on which Rita Izoma was denied the property rights, as the trial judge held that it belonged to the members of the Okoye family. Therefore, Your Lordships, resolving the fact that she is actually a member of this family by virtue of her marriage is important to this particular case, as it will entitle her to the property rights that are availed to every other member of the Okoye family. And we submit that there was an injustice in regards to that. In response, we submit that the award of 20% of the value of the property is much appreciated. But for as long as it neglects to consider the factors such as the length of the marriage, what specific monetary values or is attached to each and every non-paid domestic work that Rita Izoma performed, the life expectancy of the spouse, we submit that the 20% is not reached at rightfully, and justice need not only be done, but also seen to be done. The neglect of these other factors, as it is not seen in our facts, is outright an injustice. Your Lordship, we pray to this honorable court in regards to that there should be a consideration of each and every factor that is pertinent towards the availment or quantification of the non-monetary work that was performed by Ms. Rita Izoma, as evidenced in paragraph 11 of our fact sheet. We equally submit that that consideration being paid to how much the respondent was taken care of as a man neglects, and looking at Rita Izoma as doing little, neglects the fact that, neglects her traditional roles as a woman, neglects to look at the fact that she cannot necessarily be compared to the man in terms of energy, in terms of, I'll stop at energy. And it does.
You can use the word demeans.
You're treading on
demeaning.
Yes.
Much obliged, Your Lordship.
Not neglecting.
I will adopt the demeaning. Demeans, well, Your Lordship, submitting on the same, looking at Article 33, specifically Clause 3, it requires that the court should take into account the unique status and natural maternal functions of women in the society. Rita Izoma, as a woman, is supposed to look after the children. Our facts don't point to the fact that Robert Okoye has even done anything in regards to the children, except paying school fees. But Rita Izoma wakes up every morning, takes them to school, makes sure their hair is kept, takes care of them, cooks food for the family and the workers, and equally does contribute towards the growth of the vanilla by providing manual labor and helping in the harvest, selling, and all these things are, when neglected or when compared to what the man can do or what responsibilities the man is handling, is neglect of the unique status that she is. And it is our submission that consideration should be paid to the uniqueness of the woman in award of in award towards her contribution towards the same. Your Lordship, we conclusively submit that there is an outright injustice being perpetrated against Rita Izoma. That is by not looking at every other factor, such as the subsistence of the marriage, the length of the marriage. In our facts, it is 16 solid years which she has been married. And by neglecting the 16 solid years that she has been married, the trial court does not arrive to a proper decision by awarding her only 20%, while despising or demeaning all the other factors that really needed to be taken into consideration. And we pray that this honorable court be guided by the case of Father Nasensio, and Father Nasensio to reevaluate the evidence that has been presented and thereby arrive to a decision, its own decision in regards to the matter before this honorable court, and equally reinstate the position or make a pronouncement in regards to the rights of women in marriage, during the marriage, and at the dissolution of the marriage. If I am of no further indulgence, I'd pray to.
Just a question.
Please.
Respondents' counsel had indicated in her submissions that this court is not sitting as a constitutional court on interpretation of inconsistency with the Constitution. I've not heard you address that point. Would you like to touch base with that?
Much obliged, Your Lordship. This honorable court, in as much as it has the authority to sit as a constitutional court, it is not sitting as one. But that does not deter this honorable court. Or this honorable court cannot simply look away while the right of the appellant is being violated. And our prayer today is not for this honorable court to make reforms in regards to laws or anything of that kind, but rather to reevaluate the evidence that has been presented and to arrive to a decision by this honorable court and grant the appellant more than 20%, that is to say the 50% that she sought for, and a share of the matrimonial property. And, Your Lordship, that can be done by this honorable court as it has powers to do that. I so submit.
John Isaac, the respondent also raised an issue on some sort of justification for the 80%. And he read out the capital expenditures of the respondent that would justify his 80%. Maybe in your rejoinder you should have mentioned or rejoined on that aspect.
Much obliged, Your Lordship. I did make mention of the fact that considering what a party is doing or the amount of work that they are doing, just as the respondents did, that the respondent had a lot of work to take care of with the 80%. That neglects the fact that Rita Izoma equally had special roles that Robert Okoye could not do. And these ones have not been attached value to. And that is why we are praying to this honorable court to attach value to these roles that Rita Izoma played, thereby uplifting her from the 20% and warranting her to more than the 20% that she was being availed with. And it is equal our submission that, in accordance with our facts, Rita Izoma is seen to be complaining that the 20% is not enough, as she had labor to pay the people that were employed at home, groceries to buy, and that is for the things that were not grown in their gardens, and the 20% was not enough. It was already unfair that Robert is not considering to actually increase the money that she was receiving to take care of the family. Even while she was doing all these so many other things, there has not been value attached to them. And that is our prayer to this honorable court, to attach value to the things that Rita Izoma did.
Very much, Counsel.
Much obliged.
You've rested your case. Yes, we have come to the end of the hearing of this appeal, and I would want to thank both sides. We shall give, more comments at the tail end after we have returned with our scores. You are aware how the scores are done. We have given each individual scores alongside the segments we gave, and those will be tallied by your lecturers, who I know are very fair people. They won't mix up the scores, and then we shall come back with your final score, and we shall also come back with a few discussions between us of how we think you can do better, or what you've done very well. Because there are some things we are very impressed with and some things you're not so very much impressed with. We are going to go on recess. Yes, yeah. Before, at what point? right now, so she can go. Yes. Before we break off, we have a very important person with us today. And I think you know that much of what you do outside, the normal school curriculum has to be funded. It takes a bit of money to put all this in place. So we have our kind donor, IDLO, and somebody's going to speak to us from IDLO. So she could be introduced by Miss Biarugaba Adriko. Can you please introduce her? And then she can come and speak to us. And maybe yourself, introduce yourself.
Yeah. Thank you very much, my Lady Justice. Allow me, your lordships, the audience, to invite Barbara Kiley, the country director of IDLO, the main funder, main partner for this event today. I read that tweet that said we should leave the auditorium looking like this for the whole weekend. She's the person responsible for the way the auditorium is looking like, and she's also responsible for encouraging the judges to come to this platform to preside over this Moot competition this afternoon. Barbara, I have the pleasure and honor to invite you to say a few words to us before the judges go into recess. Thank you very much.
Thank you. The Lady Justices, my Lord, it's an honor. I think this is the first time I'm keeping a bench sitting while they are waiting to go and deliberate on a decision. It's an honor that it's quite immeasurable. Thank you very much. Ladies and gentlemen, to the students, a pleasure to be back into the lecture halls. It's been over some 20 years. Looks very nice. I enjoyed the Moot. Ours is to say the International Development Law Organization is an intergovernmental organization that's made up of many member states. We are treaty-based, and Uganda is one of our country members, and we are happy to be partnering with the government of Uganda and the judiciary of Uganda specifically, and other partners such as FIDA to promote the rule of law. Now, of course, you know customary norms and practices and customary law, and dispute resolution is part of the rule of law. And we are happy that in this particular instance, the students are using this opportunity granted to them to try and see whether in upholding the objectives on cultural norms that is in the Constitution of Uganda, you can get the judiciary to actually make a determination. Because remember, judges do make case law, do have judge-made law, sorry, that is the proper term, that judges have the right to interpret laws and make them applicable and implementable. And therefore, in reviewing customary norms, then they do have the right to determine whether or not they are repugnant. To promote your learning opportunities, and to also see how you can go back to the communities you're from and continue teaching others about what the law is, what the law should do, and how it is used as a tool to sustainably promote societal cohesiveness. Thank you very much, my ladies, your lordship. Thank you. Have a good afternoon and all the best.
Your Lordships, we will allow you to go into recess. Thank you very much.
Maybe before you stand up, we propose to break for 15 minutes. We'll try and keep it within 15 minutes. So you should be back by then.
All rise. The court is in session.
the Republic of Dakala in the Court of Appeal of Dakala at Chiate, Civil Appeal number 274 of 2024. Rita Izoma, the appellant, versus Robert Okoye, the respondent. The court is back and is ready for the ruling.
Yes, good evening once again, and thank you very much. We are back for the last leg of today's proceedings. We are not going to give a ruling in the traditional form of a decision, no. Because our understanding of a moot is a problem question was placed before you for purposes of improving your skills, as lawyers, as budding lawyers. The intention was for you to understand the facts and how well to relate them to the law, and as you did so, as much as possible, every skill expected of an advocate coming before judges was being tested, okay? Was being tested against us watching you. We are just going to give general comments of what the problem was, what we would have expected for you to traverse. We are going to tell you where we thought you were strong, where we thought you were weak, and where we think you can improve. So let there be a sigh of relief. But at the same time, we are scoring you individually. And because at the end of the day, we have to decide who was best in a certain category. And of course, your individual results added up to who will take the trophy, which side is the best, okay? You may think maybe naturally since we've taken the trophy, so the appeal has succeeded generally, or otherwise. But that is as far as we are prepared to go, and I know that satisfies what your lecturers were looking for. So, we don't have a lot of time since everything has fallen behind, but before I make the concluding remarks, I'm going to invite any of my brother or sisters here who may need to say something. This time I'll start on my left, and then we shall conclude.
Thank you very much. I just want to thank all the teams, because reading through the materials, the hypothetical question, this was a very complicated case, not so? So I think you should pat yourselves, all who participated in this moot. And I think from the preparation of the submissions, you can see the teamwork, because I think this is team effort. We had the opportunity to read through all the submissions, and they were well researched and well written. I think you also should clap yourselves for that. I will dwell on just specifics, like 2 or 3, which I might call observations. I'll start with what is important, if especially in litigation or especially in appeals, is what are the key questions of fact or law. So at the end of the day, what was this appeal about? Can somebody tell me in 1 or 2 sentences, what was this appeal all about? If you go to sleep and you go back to ask, you ask your family asked you, what was the moot about? Will you start the story, you know, this one was married, what she was there, you know? You need to be able to identify the key cracks, what we call the cracks of the case. You recognize them, and that's what you focus. You focus on what is at stake, what is the appeal about. Then at this level especially, I think they called us, is it Supreme Court? Are we Supreme Court, Court of Appeal? At that level, you're looking at issues. These are courts which make law. So the arguments are matters which need change. So when you're arguing cases, you're not just arguing for your client only. You're arguing for the rest of the women in the community, women in Uganda, and the communities, and you're trying to also influence policy and law reform. Then it brings me to an important part of this process is what kind of ruling I expect. When you're starting this moot competition, you have to start, those should be the questions at the back of your mind. Because I realized not much effort was put to the section of prayers. People are just arguing these other issues, but prayers were given 2 minutes, 3 minutes, 1 minute. I think even the respondents, did you say much about your take on prayers? So at the end of the day, what do you want the court to do for you? That is what matters. And let's remember, at the end of it, that's what determines the order of the court, which comes out. It's not your arguments on the other side. Lastly, this case I found it very interesting because it was like, it was a comparison about the rights of individuals vis-a-vis the rights of a community. Again, it's about customary law and statutory law. Those are now the issues which I think should have targeted your arguments, and then you'll be able to feed into what the moot theme is all about. Lastly, I'll talk about the arguments about enforceability issues. People were talking of 20%. Did the court quantify what 20% amounted to? I think that should have been the core argument of the appellant. What is contained in the 20%? I think one of my colleagues will talk more about it. What is contained in the 50%? What will make it, what should they add to make it 50? So mainly, if we're dealing with property rights, it's more of quantification of rights in terms of numbers, monetary, not just in the abstract. But I think everybody did so well. We're all impressed. We're talking in a common room and saying, the quality of the legal education is high. Thank you very much.
Yes. Thank you very much, Lady Justice. Since we are now approaching 6 o'clock, I'm going to suggest that my dear judges, yes, 3 minutes for each one should suffice.
You should have done.
I forgot to.
Thank you, my lord. Thank you very much for that performance. Clap for yourselves. Seriously. I think you should enjoy your craft. Put some joy into your craft, right? I'm going to be doing this for a long time. You should try and enjoy your craft. Is what I think you should do. Yes, it's a competition. Yes, it's a moot. But we can tell if you're stiff or if you're comfortable with what you're doing. And I know sometimes we like to think that when we are representing our clients, we're on stage. We might be in a manner of speaking, but it's important that, I don't know how to put it, I pray I'll find the words. You need to be one with your client's case. Maybe let me use, I hope that's Gen Z language enough. Don't be so academic that you detach yourself from your client's case, because I can tell if you've been memorizing, I can tell. And I want to know that you have appreciated your client's case and it's flowing through you. You're your client's mouthpiece. It's not easy to hone, but you can get there. You can get there. As long as we don't commercialize our craft, we are lawyers, don't commercialize it, sorry. You can get to that point where when I'm looking at you present your case, I'm looking at your client, but it's a more articulate and fine way of presenting the case. You understand what I'm saying? Yeah. Do you understand what I'm saying? I hope I'm getting through. That's where the confidence comes from. That's where it will come from. You have to have studied your material, appreciate the case, and be passionate enough to deliver it in a very convincing way where I actually can't tell whether it's the client who is presenting or you're the one who is presenting. Understand? Yeah. If you can hone that craft, your moods will be smooth. But thank you so much. You gave us a nice afternoon, a nice evening, and enjoy the result. There's a trophy for everyone, apparently. So thank you so much.
Okay. Thank you, my Lord. My comments are going to be general and specific, but brief. I'll start with the side of the appellants. When you read through the facts of the Moot, they were told that Dakala is a dualist state. I did not see it coming out, and the best way to unpack that, you would have started from the Constitution that brings in the applicability of international law. And then you unpack it, bring it to the regional law. You are coming in telling us about Maputo Protocol. Where does it come from? And how is it related to our Constitution? And you rule out monism completely, because we were told that this is a dualist state. So that one had to come in to see how does it influence the national law of Dakar. The language, you will get it as you go along. Don't get worried. As somebody said, generalizing, I pray that this court grants ladies like Rita. You are here for Rita, like her lordship said. You are the mouthpiece of your client. There could be so many other Ritas, but you are specifically here for Rita. Then, thank you, John Isaac, for making the reference to the Evidence Act in relation to the admissions that were in the facts, but you can better it up by showing how judgments on admission are entered in the rules of the Court of Appeal and even in the rules of the lower courts. You can look at the Court of Appeal rules and the civil procedure rules. That should have been one of the prayers, that for this part, I pray that judgment on admission be entered in this respect, because Robert is not contesting ABC. That is one of the prayers. Then next, point out how the trial court erred. We're here talking about the issues, but you had to specifically say at this page, this paragraph of the judgment, the trial judge held like this and that. But this was an error, and this is how the law provides, and you tell us how you are interpreting it, such that it becomes easy for the appellate court to know exactly where the trial court went wrong in those assertions. Then try as much as possible to think that you are appearing before human beings. Issues of intimidation, first put them aside. Practice how to be calm and how to move on. We're being told, still language, case, appellant, number. This was just a civil appeal. You should have been referring to it as a civil appeal, but not court case appellant number. Then, when we are addressing you or you're addressing your colleagues as counsel, in English, we do not have the word counsels. It stays, or you want to be set aside and your prayers to be granted. You are not in the appellate court to defend the trial court. Taking into account issues of dissolution of marriage, that was very good. I think this was Opolot. saying that this husband even kept paying school fees. That is why the wife should not get the 50% asked for. And he tried to, you could see somebody who is arguing a client's case, trying to justify why the 50% should not be granted. Otherwise, it was a very good performance. I know as students, you are going to become much, much better as you go along. Wishing you the very best. Thank you.
Thank you, my lords. I would like to reiterate that indeed it is very important if your counsel to be the mouthpiece of your client. Put yourself in the shoes of your client and then argue the case on that basis. That is very, very important. The element of dualism, as has been mentioned, should have been really very key. You could have made reference to the Interpretation of Treaties Act, which allows for domestication of international treaties before you actually cite them. So that is very imperative. You don't cite an international convention in this particular scenario where the information has been indicating that it is a dualist state without reference to how you actually domesticate those conventions and how they're utilized in national law. Having said that, essentially, the issue to me should have been revolving around the contribution of the appellant vis-a-vis that of the respondent. That was the crux of the matter. And that is the major issue as to why the appeal was brought. That you see, the appellant's contribution was wrongly quantified at 20%, whereas the respondent was given 80%. And then you have to go back to the decision of the trial judge as to whether he made the justification. And for the appellants, I think there was a good attempt at trying to draw the case out. Paragraph 19 of the case scenario, I think one of our judges did make mention of this, where the trial judge said, he then stated that, no, this case summaries, the trial judge stated that when assessing the value of unpaid care work, due consideration should be given to the price at which similar services are available on the market. But the summary goes ahead to say, he, that is the trial judge, however, did not indicate the specific market value that he attached to each form of unpaid care work that Rita had performed during her marriage. For the appellants, that should already be drawing red flags and say, this is the crux of this appeal. That you see, even though he went ahead to say 20% to Rita, he actually did not assign specific values. In other words, he didn't show how he derived the 20%. It is not simply about how they decided to divide the proceeds of the vanilla, that you say I take 80%, you take 20%. It should be about the quantification in terms of the divorce proceedings. So that should have been drawn out a lot. I know, Ocho, you did really make, in your rejoinder, at least that came out, the contribution of the appellant, the marginalization of the role of this rural woman and her contribution, the fact that unpaid and unquantified monetary value to someone's work should not be underrated. And that should have been blown out. You should have gotten more into the works in respect to that particular argument. Now, the interplay between the Constitution and the Land Act is a good one, but ought to have been dwelt on a little bit more. When you talk about the custom, the practices, the communal ownership of land, vis-a-vis the rights of this rural woman, what are you essentially saying? And what do you want to draw the Court of Appeal to look into and to reconsider, you see, for posterity's purposes? So again, I will repeat that there was a really very good argument on both sides. And some of your arguments are really much more great compared to some of our counsel who come before us in some of the cases we hear. Yeah? So you have done tremendously well. And I know it is not just counsel on both sides who have worked. You also have teams amongst those of you who are seated in the background. So we do appreciate all of you for that intricate deliberation and participation in this moot and the preparation there too. Yeah? So we do encourage you to enter into the works. I mean, feel it. It is like if you go into, maybe in a disco or something. I mean, you can't enjoy it until you enjoy it, right? So if you are counsel, you should really feel the spirit of being counsel and not just be part of your client's case. You should actually be like your client. See ways in which to project your argument in a very convincing, authoritative manner to get the best result out of that particular case. So I appreciate all of you. Thank you.
Thank you very much to both teams. Like my sister and brother have said, or will say, you actually impressed us. I want to tell you that this is not just a random case. We in the family court know that these are actually real-life cases, and the scenarios that you have actually argued about today are real-life scenarios. So don't take it like this is just one of your courseworks that you're doing. It's an actual real-life scenario. So we were impressed by your arguments, and you should keep it up. Just a couple of questions. I won't repeat what has been said. Mine is just to comment on how it's important for you to ensure your structure of your arguments and that structure has follow-through. I'll just give a brief example. I think it was from the appellant's side. There's an argument that Belinda, you started, on Rita not being a member of the family. So you had started that argument, and then along the way, you went into the argument that on the issue of her contribution, and then you went back to the argument of her not being a member. So it's important for you to always follow through with your arguments. So start an argument and finish it. Now, when you get to this level of the courts, you will actually encounter the interruptions that you got. And some of these interruptions might go into someone else on your team's arguments, like you saw. Now, you've got to be prepared to regroup. Now, in regrouping, maybe the person who was coming next, who had a whole long speech that has already been covered by your answer, should be able to now minimize. But the important thing is to always make sure that even if you're interrupted, remember where your flow and structure was going, and then go back to it and finish the point that you are trying to make. So always make sure that the structure and the follow-through of the arguments is done. And then I think, like Justice Dr. Christine said, you always, and Justice Immaculate said, you must always remind court and yourselves what you want to achieve. So at the back of your mind, make sure you're talking, but you don't go off the point of your issues and off the point of what remedies you want. So in resolving each issue, always have a small and short, maybe one-liner, to tell court what you want once you resolve that issue. So if it's an issue on discrimination, make sure that you show that this discrimination should not have been done, then summarize with what you want. And then the final summary will be on all the prayers that you want. Then finally, on emotive arguments, again, you used words like misogyny, patriarchy, but even when you're giving emotive arguments that are supposed to try and convince court that this is a real issue that is being felt by the community or by the world, you must go back and relate these emotive arguments to the actual case. So don't just leave them as emotive arguments, because otherwise it looks like you're just an emotional lawyer who is playing to the gallery, always get these emotive arguments and show how they contextualize them in relation to the case. But otherwise, you did a good job, and I hope this moves on to practice when you eventually finish.
It's a good evening. I want to begin by saying that when I was a magistrate grade 1 in 1990, the inspector of courts came and looked at my judgments and my work and said, "You are writing male judgments." I said, "Male judgments?" He said, "Yes. Do you mind going back to school?" I said, "To read what?" I was a state attorney, I'm now a magistrate grade 1, said, "You need to go back to school and read women's law." I was reluctant, but she said, "Every night you are at that university, you'll be paid a night allowance." I went for the money. At the University of Zimbabwe, NORAD paid. They lived to their promise. A night allowance. My sister was there also. A night allowance at your level. Just Smlia Gonja, Mama Kadaga was there, Wolayo was there, Madrama was there, and whoever was coming back from that course was being appointed a judge. But I got lost in the forest of a diploma in women's law and went back for a master's in women's law. I went as Saul and came back as Paul. Equality does not mean treating people in the same way, right? I wanted to hear that applauded. We can treat people in different ways by giving them affirmative action in order to be equal to the others. I didn't hear a word like affirmative action. I said, "Oh my God." And what we were discussing here was family. So it was important that we cite articles from the Constitution pertaining to the family. What we were discussing here was land law and land tenure, particularly that land tenure, not being mile, not being leasehold, not being freehold. What was it? Yes, I wanted a definition of what is that customary land tenure. Can it exist without the backward discriminative norms and traditions? And we look at it as land law, because the British left it to us according to our own tribes, our own clans. What pertains in Busoga may not pertain in Masindi. And where is the equality provided for under Article 20? And particularly the rights of women. We would have helped that. The rights of women, because they're constitutional. Are they a privilege? I would have loved to hear that word, that these are rights, constitutional rights, not privilege. Even affirmative action is a right. Now, when you read the rights of the family, equality at marriage, during marriage, and at its dissolution. Yes, you harped about it, but we wanted to find out, how can we be equal when we are parting? We are parting. Aren't we estranged? Isn't there animosity? So how shall we be equal? Should we allow this man, simply because he's annoyed, to take 80%? Yes, you are annoyed. You are going to lose a lover, A, B, C, D. And how many slaps were they? You remember the Kazibwe case? And somebody went on TV and said, the vice president is shaming us. Only one slap, and she files for divorce. So how many slaps should make it to 50%? Right. When we are coming here to argue a case for the women's rights, I want us to be passionate. Me, when I'm lecturing, when I'm talking about women's rights, I put myself in the shoes of the woman. It is not about sympathy, it is empathy. Right? So when we are preparing to argue these cases which require reform, put yourself in the shoes of that person who requires affirmative action, who requires law reform. And then you argue it as a right, not as a privilege. Now, when you are citing the national law, relate it to the international CIDO. I was waiting to hear CIDO, Article 14. Maputo, Article 14, that. So, once you don't relate the two, you might think it's a privilege, but it's a right. Now, when we begin from there, what is a right? How different is it from guaranteed freedom? Because you might have the right of freedom of assembly, but it's limited. Somebody tried to relate it. Is this derogable or non-derogable? Maybe we'll look at it that way. For the Moot, 3 rules. Rule number 1, prepare. Rule number 2, prepare. Rule number 3, prepare. Did you prepare to know the law applicable, to know the facts, to know how you are going to dress, to know how you are going to smile, to know how you are going to stand? I saw you people, some were standing like they were in a market. Prepare how to stand before the bench. If it was in those olden days of Justice Wambos, they would say, I can't see you. I'm hearing you, but I can't see you. Deport. How do you stand? How do you bend? How do you pick your papers? Or are you clumsy? You're picking this one is falling. We are looking at you. Prepare, prepare. Now, when you prepare, they've told you how to present. That shows you have prepared. And then, how have you prepared to win or to lose? Because once you prepare to win, you make a passionate appeal at the end of it, right? The prayer, isn't it a prayer? Do you pray casually? God, give me shoes. God, you even humble yourself, isn't it? How have you humbled yourself when you are making your prayer? I look at you, and you think I don't have the discretion to deny you what you are praying for. I will. So prepare, prepare. The language, they've spoken about it. The language of a plaint is not the language of an appeal. Memorandum of appeal, grounds of appeal. Plaint, issues, blah, blah, blah. But as my sister said, you'll go through it, you'll come to it. But I was taken aback to hear the framing of issues instead of arguing the grounds of appeal. Well, we have a duty to revisit the issues, but you are arguing the grounds of appeal. And that's the language we should hear. I wrote here and said, why am I called Sister Batema? People refer to me as Sister Batema. And I love it. Because women's rights are human rights. We would have heard that. What a statement. My lords, this is an appeal, blah, 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 blah. And then you emphasize the human rights, the gender equality, you emphasize. We are talking about a woman in a rural setting. I didn't hear things about a woman in rural setting. Maybe somebody talked a little about it. the land not under the RTA. So what is it? How can we say it is owned by a clan? The clan is amorphous. Tribe, amorphous. Is it registered anywhere that this land belongs to the Nsenene clan? When you are saying you are from the Fumbe clan, don't you remember that your daughter will be married in another clan? So the best way of putting things to the judge for judicial activism and judicial courage is to put the language in a simple way they understand. I'm talking about my sister. I'm talking about my mother. I'm not talking about women. I'm talking about my sister, my mother. Our mothers are denied. Our sisters are denied this. They are demeaned. Their work is undervalued. Right? Imagine, or imagine, whatever case you went, which school did you go to? Imagine the work we do. In class, we are taught by, is she retired? Sylvia Tamale. Is she still with us? Sylvia Tamale and Dr. Tibatemwa, and then Stuart. They told us to get a paper and draw a picture or a cartoon or a photograph, and we name it, My Wife Does Not Work. My wife does not work. So we were wondering, what is this woman who doesn't work and is a wife? First attempt, we failed. Then Professor Stewart showed us a photograph of a woman with about 20 hands. One hand was cooking, another one was sweeping, another one was ironing, another one was digging, another one was doing other things, and said, that's the picture I wanted. My wife does not work. But for class purposes, said draw 3 columns and say work. Column 1 is work. Column 2 is commercial name. Column 3 is average payment per month. Work, cooking. What's the commercial name of cooking? Chef, cook. What is it per month? You put the amount. Case number 2, looking after the sick. Commercial name, nurse, doctor, amount per month. Casual laborer, welcomes visitor. Commercial name, usher. Customer care, something like that. All right? Teaches children how to speak. Commercial name, nursery teacher, professor, blah, blah. Tethers goats. Commercial name, farm manager. Cleans toilet, sanitary manager. Is it sanitary manager or toilet cleaner? Okay. And then said, but you have left out very important work. That particular worker which made them leave their parents to come to your home. Is it short or long? How much per month? Then if you are the judge, you will know whether you are giving 20% or 80%. I would have loved this class to put that analogy and appeal to the bench when they are valuing the work to say, my Lord, it's not very hard, but the trial judge didn't do any assessment, any analysis. And you say, let's go to Article 274, 273, 274. For purposes of law reform, no moot should end without reading Article 274. What does it read like?
Use your phones. Don't you have your phones?
You even have the okay, appellant. Give him the Constitution. 274, 273, existing law. Could you read it? Gen Z. Please, Ocho, you impressed me. Read that. Article 27,
Much obliged.
existing law.
Subject to the provisions of this article, The
You
operation.
begin with existing law.
Existing law. Subject to the provisions of this article, the operation of the existing law after the coming into force of this Constitution shall not be affected by the coming into force of this Constitution, but the existing law shall be construed with such modifications, adaptations, qualifications, and exceptions as may be necessary to bring into conformity with this Constitution.
That argument would have won you the whole day. Okay, that's the customary law. Okay, that's the written law. But that's old law. It's obsolete. Let's go to the Constitution. It says this. Let's modify the law. Let's construe it. Let's understand it. Let's interpret it in line with gender equality, in line with human rights. How we would have won this moot. The existing law must be construed with such modifications, adaptations, qualifications. That is judicial activism. For these judges here, including myself, we are stupid ass. You know, a donkey. We have to be hit to move. Move, please, my lords, your lordships, move in that direction. Have the courage, you have the power to make the law. You have the power to make that declaration. You see, if you have a hunting dog, tell it, please go this way, go that way, there, catch him, You see, the Baganda have better words. Mukwate, unosula kuchitanda nze nasula wansi. Mukwate, ojja kulya ennyama nze njja kulya amagumba. And the dog is, excited enough. Okay, you excite us and we give you the day, right? I want to thank you for being a gender activist. I hope that soon we shall have many sisters joining me. I have identified the Sister Cho here. I know the other side had a very bad case, but I once asked in a mood, is it part of litigation that you can concede? My lord, I concede. I have nothing useful to urge. and perhaps you're a good lawyer, other than arguing a bad case. If you come to my firm, if I was in private practice, I would say, that's a bad case, I'm not taking it on. Like people get sick, they go to a medical doctor and says, no, we don't accept that patient. You try Kirudu. So why didn't you concede? Thank you very much.
Yes, a special thank you to my brother and my sisters here. I think they have summed it all up. They've told you everything that you need to know, that we observed. You could see this was a very well-crafted problem question. A problem question that involved many dynamics. Of course, the obvious ones, issues of a woman, issues of gender equality, issues of constitutionalism, and then they placed her in a rural setting. There was a reason why they set her in a rural. Would it have been different had she been in an urban setting? Maybe not, because discrimination against women usually cuts across. So it was really something that needed you to think outside the box. And you've done the basics. We are quite impressed. You understood the question and you tried. But what we are trying to tell you is how a little further you would have gone. And maybe I could start from there. Very passionate judge here next to me, because he received the right training. But half of the judges you're going to go before have no inkling what you're talking about in human rights. It is only very new. When we went to school, I'm even wondering, what year are you? What year are you?
Year 3, year 2.
Year 2, year 3?
Year 1.
Year 4. And you're taking the human rights elective? What is your special? It's a special specialty? Is it a core subject or? Yes, you see?
Yeah,
what is it called? Good. So that's an elective that did not exist when we went to school, even 10 years after we left. So the judges that you're going to go before, unless somebody has interested themselves in learning human rights or has obtained special training, they still work much in the old ways. So like it says, you have to be a hunting dog. You have to convince, because some judges will say, well, the law is clear, the customary law is clear, the constitution is clear. What are you talking about? I think this judge was fair. So then you must convince. You are lucky that, probably 3/4 of us here, or maybe the whole of us, and that is why we're chosen. We understand human rights. You're going to go before judges who absolutely. So you go before a court that you think is ignorant about the issue you want to bring forth. So you are teaching the court, you are persuading the court. Don't assume they know. Don't leave back anything that you think was going to be important. I think what I also noticed there was a lot of conflict of laws, and that happens a lot in most of the human rights discourse in Uganda. The constitution was put at a pedestal quite high. We've got probably the best constitution, one of the best constitutions in Africa. So it is placed at a pedestal, yet the substantive law is left floating with all the problems that you know. So now you're trying to ask a judge, the constitution is up there, the subsidiary law is not quite where it should be. So now you're trying to show the supremacy of the constitution, because that's your go-to. That is your go-to remedy. But how do you actually get there?
Sorry, for that purpose, I heard the word null and void, and I didn't like it. The Constitution does not provide for null and void. If you read Article 2, to the extent of the inconsistency.
Yeah. So how do you go about that? Then I didn't see much use of the constitutional national objectives, that little introduction. It has now been made part of the Constitution. I tell many students I teach, when you are stuck, you're going to find something in there, in the national objectives, because they're kind of pointing to the general aspirations of Ugandans. And it can be important. There was a lot of use of the Asenua case. I think it's a constitutional court case, isn't it? It is the one about where they gave the woman 20%, 40%, against, what was, you read the case? They gave? Asenua. You've forgotten? You people, you were quoting it like Ambayo, sorry, Ambayo, the Ambayo case. What was given? What were the proportions given? You people, you've just, okay, fine. So they considered, yes, you're trying to answer. 30 against 70. And this was a woman who, they told her she just went and used to visit the building site. For what? For leisure. So many, it was from my own court, I must admit. But remember, we have Rabbi Numi. I didn't hear much about Rabbi Numi.
There was only one.
Yes?
Only one.
Yes.
Only one.
Come up. Rabbi Numi was Rabbi Numi is still good law. Where you find maybe Ambayo might have a few. I think the judges there tried to equate the services of a woman, which you also try to do, the services of a woman against what can be quantified in other labor, okay? And I think they try to even equate it to the International Labor Organization, okay? But can you actually say a woman in a home, you can equate her to, for example, an accountant in an accounts firm? Can she withdraw her services and go to a trade union, for example? Some of those things. Can you actually equate it to ordinary work, okay? So we must respect women because they are equal partners in our lives. That is the strong point. Much else has been said. The issue of rural women, there's a lot said in, he said it in SIDO. SIDO has very progressive provisions as well as the Maputo. But like it has been stated, you did not actually bring international law as much as we had expected down to the domestic arena. Yet you knew, because all of you were quoting, and somebody actually even went into some of those general recommendations, okay, which was very useful. About the practical aspects, I think you prepared well, because we could see, we read your submissions, but don't ever estimate the power of preparation. And that happens a lot with the lawyers who come before us. You can see clearly, the court can clearly tell a party that has not prepared. Preparation also includes good pleadings. Lawyers overlook that a lot. Learn, I think you've done, I don't know if you're doing civil procedure in third year. You did it in third year or fourth year? Yes, and it's compulsory. You're taught, of course, you're going to be taught even better at LDC. If you don't have good pleadings, you annoy me even before I meet you, okay? By the time you come, I've got I'm in a very bad attitude, because I'm reading your plaint and it's got a lot of mistakes, and you have already alienated me as the court, and that is not good. Otherwise, the presentations were good. I liked some of you. I won't say who. Somebody who looks straight in the eye of the judge. Don't fear to do that. Let the judge drop their glance. As long as you're not doing it in an impertinent way, okay? There's no fear. Yes, there's no fear. Your body language, remember how we told you, settle down. Yes, we know, even for who have served, who have worked long as lawyers. I worked as a lawyer for 20 years. There are times you would come before a judge and you are just full of nerves. Maybe because you know you don't have a good case, or it's just a bad day for you. You can even tell the judge, can I take my breath, okay? And you can, like you did when you took your breath, you are able to quite well, because you might have come with your very good points, and then you just get this case of nerves which you failed to handle. But I can tell you from experience, once you start with the simple things. Don't start with the most difficult. Start with the simple things. Within 5 minutes of your address, you are in the flow. And then you are able to... there was a lot of issues of communal land, and that has been invariably talked about by my colleagues. We wanted you to unpack what actually is communal land. You know, what does community mean, in fact? Okay, who owns it anyway? Is it this man? Is it his family? Is it a wider one? And how can women fit into that when they get married? Of course, this is you are opening floodgates. You're opening floodgates, but with issues of women who are majority are going to be closed out of these rights to land, you might have to open the floodgates. And I think the subject here was not only ownership of land. There were issues on use, land use, and being able to benefit from the proceeds. Yeah, that was in the beginning. She was being prevented even to share in the sales of the vanilla. Yet she's the one who was toiling together with her husband. All those issues are very important, and like Judge said, they are in the family division. They get them on a daily basis. So with that, I think that is all I have to say. But to thank you very much for giving us the opportunity to be part of this very important exercise. Thank you very much. The final decision is that all you did well. This was, of course, a case not so easy for the respondents. The judge here asked you to concede. I wouldn't. I would have a very different, answer to that. Of course, for the Moot, you had to go all the way, but you also had important points. Remember that in every case coming before court, one party may have a bad case, one may have a stronger case, one may have a very bad case, but then find just that one little law somewhere, and you completely floor the other side. So even when you're faced, don't just send away clients all the time, but yes, there are some clearly bad cases, and in that case, you open up your client to what we call alternative dispute resolution. Don't send people away from your farms because you have to make money, and they want to resolve. They might not get 100% of what they wanted, but there's a win-win situation at the end of it all. But this was an academic exercise, and your lecturers expected you to make and to come up with an answer and defend it. And I must say both of you did quite a good job at it. So everybody's a winner. So the court has adjourned, and we hand over to Makerere University Law School, Hurie Peck. Yeah, let's read the results. Best orator?
No, we have given them enough.
We have given enough. They are tired even. Like on the attention span. Attention span not you know give a leader. Again,
Yeah, but what the attention?
Yeah, they have.
They gave us very good attention. Friday? Ngaha, bupate butandise.
Okay, just let me. So, your lordships, I just want to say thank you very much once again for making time to be with us this afternoon. To the students, the representatives, Makerere School of Law, PILAC, thank you very much for making time to be here with us. I'm going to request that we give out the certificates and we award who we consider the winner for today. While you're still here, we'll quickly go through it, but I think it's a very important part of why we are here today. So we'll start with our host, Makerere University School of Law. Please send a representative to pick a certificate from us. As well as public PILAC. So my Lady Justice Eva, if you can please help us to give out the certificates, we'll be most obliged. Yeah. Please allow us to request you to come down here. Thank you. So this is Makerere University School of Law.
Okay.
Thank you very much.
And she's also the Makerere Law Society president. So, thank you.
It's good to see women in power. The next certificate goes to Public Interest Law Clinic, PILAC, who's the representative.
Okay, our logistics/advocacy officer will receive that.
We insist that we have male allies as well, so good to meet you too.
Thank you.
It's okay. So we have Ocho John Isaac. This is a certificate of participation. My Lord Justice already identified you as a male ally. We will follow up on that. We have Nakalule Hajara. Please come forward and receive your certificate of participation. We have Amanya Belinda. We have Mwine Andrew. Okay. As Mutesi Sandra comes forward as well. Your Lordship, these were the participants that appeared before the judges in the morning. Well done, Mwine Andrew. Mutesi Sandra. Oh, sorry. Evelyn Angela Nsemere. Can we have Nabakoza Faith Kakoza come forward as well? Nabakoza Kakoza, interesting combination of names. Well done. Katusime Elizabeth. Musiba Joel. Could we have Banda Agnes coming down as well after Joel? Is Joel still here? Thank you. Banda Agnes Changu. Isabel Akankwatsa. Gabriel Ejai Opolot. Who has that? So for Best Memorial, it was Team G. Best Memorial, Team G. That's Ocho John Isaac. Please come forward. Nakalule Hajara. The entire team should come forward. Amanya Belinda. So this is the Best Memorial. Congratulations. And that's their, yeah. Thank you. Best Oralist. We'll start with the second best, and this is Isabel Akankwatsa. Hearty congratulations. Ocho John Isaac. Ocho John Isaac is the best oralist. So that's the second best oralist, and our new male ally is the best oralist of the day. What? First runners up is team led by Gabriel Ejai Opolot. First runner up. Please come forward, the whole team. Isabel, and Evelyn. That's best runner up. Congratulations. Okay. Yeah. Okay. So, your lordships, ladies and gentlemen, allow me to have the singular honor to announce the winning team for the day. That is the appellant team. Team Gulu. Please give them a louder hand clap. It's a confetti moment. Our partner IDLO, please take note. Next year we'll need confetti to celebrate this moment. Congratulations, hearty congrats, and we are going to hand over the...
I suggest we give them a standing ovation.
Thank you.
Yeah.
Hearty congratulations. Team Gulu. Team Gulu didn't participate last year, but here we are. Yes, this is Team Gulu. Yes.
This is a relatively new university, isn't it? Thank you so much. When we tried to, Law School of Gulu, come on, give them another clap. I didn't know. I'm sorry we didn't ask all those questions. When LDC was trying to decentralize, I was one of the people who was adamant. We cannot decentralize these things. We shall be diluting. How is it going to work? You know, I was a naysayer. But now look at this. Gulu, law school, competing with MUK. In our times, it was the only university. You must be happier than this, surely. Congratulations. Keep it up. Keep it up. Because, you know, when we open up these other cities, it shows that Uganda is growing. And it's growing equally. You know, we are all not going to concentrate in Kampala, yet there's so much going on there. Thank you very much.
Thank you very much. And allow me to add that FIDA is actually carrying out interviews from Gulu University, and what we intend to do is to award the best interviewed person a scholarship with support from somebody from Austria, and they will take it right through to doctoral studies. So there's very many things going on under the Leadership Academy. I'm very proud to be, you know, handing over this trophy to Gulu team, and I'm hoping that better things will come out of there and from the other universities as well. Thank you very much. Thank you in the utmost for hosting us. We wish you a very lovely weekend. Thank you. Okay. Your Lordships, I have the final request for you to stand where you are so that we can have a picture with the winning team. You don't have to move. They'll see you from right there. Yes, I'll join them. Elizabeth, may I hand over the MC role back to you?